afternoon. May we settle down so that we could start. The President of the Law Society of Kenya, Mr. Nelson Harvey, the Vice President of the Law Society of Kenya, Madam Caroline Kamende, the Chairperson of Kenya Christian Professional Forum, Mr. Charles Kanjama, Council members present, our colleagues and panelists, Mr. Nzamba Kitonga, Senior Counsel, Madam Atsango Chesoni, Mr. Abdigadir Muhammad, Mr. Kamodo Waiganjo, Dr. Jaramba Gishuki, colleagues, Kenyans, good afternoon. My name is Mercy Wambua. I'm the Chief Executive Officer of the Law Society of Kenya, and I also serve as the Secretary to the Council of the Law Society of Kenya. I'd like to appreciate all of you for finding time to join us, those who've joined us physically at the Law Society of Kenya Secretariat grounds on Gitanga Road in Nairobi, and those who have joined us online. We apologize most sincerely for starting late, and also appreciate those who were part of the early morning session. We started at the Holy Family Basilica with a church service. After that, we proceeded here. Nonetheless, we are going to start our program today. I'll be asking that we be upstanding for the Kenyan National Anthem and the East African Community Anthem, and thereafter we'll have a prayer.
Haki for gathering us here today, even as we commemorate the 10th anniversary of the Kenyan Constitution. We commit ourselves to you as professional bodies and also as religious bodies. We pray that you may give us the strength and the wisdom henceforth to defend, to protect, and to promote the Constitution of Kenya and all the values that it stands for. We pray today, even as we engage in this discourse of this Constitution, that Lord, you're going to help all the conversations that we shall have here, that they will have an impact in this generation and all the generations to come. We thank you and we worship you. In Jesus' name we pray and believe.
Thank you, Patience. We may take our seats. And as we take our seats, let me appreciate the presence of representatives of various professional bodies as they continue to join us both physically and online. I'll ask the Executive Director of KCPF, Mr. Vincent Kimosop, if you're already here. In his absence, do we have a representative other than the chair from KCPF? Patience, come back again. You give us brief welcoming remarks.
Good afternoon, everyone. To the President of LSK, Advocate Nelson Harvey, the Chairperson of KCPF, Advocate Charles Kanjama, and all the professional bodies who are represented here. We welcome you today to this commemoration of the 10th anniversary of the Kenyan Constitution. And as we start this day, we just want to appreciate all of you for accepting to come here and to join us. KCPF is an organization that brings together Christian professionals from all denominations, and we are happy to be here today. So welcome all of you and feel at home.
Thank you, Patience. This commemoration and 10th anniversary of the promulgation of the Constitution of Kenya event has been organized courtesy of the Committee of the Law Society of Kenya, Law Reform and Implementation Committee, chaired by Madam Erin Kabita, in collaboration with KCPF and with the support of Found Foundation. Would like to appreciate most sincerely the support of Ford Foundation. At this juncture, allow me to invite the chairperson of the Law Reform and Implementation Committee of the Law Society of Kenya, Madam Erin Kabita, to give us a few remarks.
Thank you, Madam CEO, Mercy Wambua. The President of the Law Society, Mr. Nelson Harvey, the Chair of Kenya Christian Professional Forum, Mr. Charles Kanjama, Council member present, representatives of various professional bodies present, members of the bar, distinguished guests, ladies and gentlemen, good afternoon. Today, I represent the Law Reform Committee and I want to make a few remarks. We commemorate the 10th anniversary of the promulgation of the Constitution. The Constitution requires the state to take positive action to give effect to its norms, values, and principles. The Constitution has also provided various mechanisms to enforce its values and principles. As part of Constitution implementation, there have been enacted several legislation related to the structure of government. The judiciary, as one of the arm of government, has played its important role of interpreting, safeguarding, and protecting the Constitution and its values, and thereby contributing towards the consolidation of constitutionalism and democracy. There has been advances in Constitution implementation as well as challenges. While constitutional implementation as envisaged by transitional provisions has been realized to a greater degree, there remain significant challenges to the substantial realization of the constitutional purposes. We welcome you today as we mark the 10th anniversary of the promulgation of the Constitution of Kenya. Professions today will proclaim to uphold constitutional values, and thereafter we will have a discourse on the implementation status of the Constitution, and the prospects for the future. At this point, I wish to invite the Vice President of the Law Society of Kenya, Madam Caroline Kamende, to make her remarks before we proceed on. Thanks.
Thank you, Herin. The President of the Law Society of Kenya, Mr. Nelson Harvey, the Chairperson, KCPF, Mr. Charles Kanjama, the representatives of other professional bodies present, council members present, senior members of the bar present, our distinguished guests who are the panelists for the day today, Madam CEO, and all other members of the bar watching us from wherever they are, and members of the public, good afternoon. The Constitution of Kenya is the supreme law of the Republic of Kenya. There have been 3 significant versions of the Constitution, the most recent draft being enabled in 2010. The 2010 edition replaced the 1963 Independence Constitution, which was presented to the AG, the Attorney General, on the 7th of April 2010, officially published on 6th of May 2010, and was subjected to a referendum on 4th of August 2010. The new constitution was approved by 67% of the Kenyan voters, and thereafter it was promulgated on the 27th of August 2010. Constitutional reforms involving wholly new texts since gaining independence were done in the 1969 and the 2010 Constitution. In 1969, the 1963 Independence Constitution was replaced with a new text that entrenched amendments already made to the system of the government that the Independence Constitution had contemplated. These changes including changing the structure of the state from a federal or majimbo system to a unitary system, creating a unicameral instead of bicameral legislature, from a parliamentary to a semi-presidential system with a powerful presidency, and reducing the protections of the Bill of Rights. Further amendments to the 1969 Constitution were later effected, including in 1982, the institution of de jure single-party government. The demand for a new constitution to replace the 1969 texts with a more democratic system began in the early 1990s, with the end of the Cold War and the democratic changes taking place elsewhere in Africa. Calls for a comprehensive review of the 1969 Constitution intensified in the late 1990s and 2000s, helped by the victory of the then NAC party in the 2002 general elections. No doubt, and it has been said everywhere, that this constitution has been hailed as the world over, as one of the most progressive constitutions in the world. Yesterday, during the 11th presidential address, President Kenyatta said, and I stated, and I quote, "But 10 years after our progressive constitution, the moment calls us to do better. Instead of a ceasefire document that enforces a zero-sum game in which the winner takes it all, the moment calls us to create a constitutional order that will long endure." And then he went on and said, and on this I want to emphasize that we must not go for the populist path. Let us choose the bold path, that path that will assure Kenyans of sustained peace and security and shared economic prosperity. End of quote. Today we commemorate the 10th anniversary of the promulgation of the Constitution of Kenya 2010. The questions that linger in our minds today are, have we made any inroads? Is the problem the document itself, the contents? Have we committed ourselves to this document since 27th of August 2010? And what are some of the biggest achievements under the new constitution? What are some of the biggest laws and losses that we have gained over the 10-year period? Many people argue that we have a good constitution, but the problem is implementation. Is it time to amend the constitution? Have we identified what needs to be amended? Have we also identified the challenges? Are we told that we need to amend this article because there are challenges in implementing the same? And that, ladies and gentlemen, will be the discourse today. We have great panelists present today, and I take this opportunity to welcome you all to today's discussion. And I'm sure by the end of it all, we will all have got a way forward on this journey of the Constitution of Kenya 2010. I wish you all fruitful deliberations, and once again, welcome to the forum. Thank you. I am reminded to take this opportunity to invite now George and Caroline Mudeu, council members who will be today's moderators for the session. Thank you.
The President, Law Society of Kenya, council members present, senior members of the bar, the CEO of the LSK, distinguished guests, ladies and gentlemen, good afternoon. I'll read the proclamation by Kenyan professionals to promote constitutional values and to commemorate Katiba Day. We, the professionals in different professional bodies and associations in Kenya, acknowledging the supremacy of the Almighty God of all creation, His leadership over our country, its laws and people, honoring the Constitution of Kenya 2010, its promulgation on 27th August 2010, and its continued direction and guidance in our beloved country, Kenya, over the last 10 years, committed to uphold and defend the Constitution of Kenya 2010, as well as to nurture and protect the well-being of the individual, the family, communities, and the nation. Grateful that as a nation, we have achieved this milestone of recognizing 10 years since the promulgation of the Constitution of Kenya 2010 on 27th August 2010. Now, therefore, we the professionals in different professional bodies in Kenya, in commemorating the promulgation of the Constitution of Kenya 2010, wish to have 27th August be marked as the Constitutional Day, Katiba Day, by all professionals and Kenyans of goodwill. We hereby commit to recognize and appreciate the said promulgation every year and to uphold the spirit and the letter of the Constitution of Kenya 2010, we also commit to recognize and promote our national values and principles of governance under Article 10, our cultural foundation as a nation under Article 11, and the family as the natural and fundamental unit of society under Article 45, as enshrined in the Constitution, and advocate to have them upheld and defended in our beloved country, Kenya. This proclamation does not intend to mark or set aside 27th August as a public holiday. In witness whereof, we have hereto set our hands this 27th day of August 2020 on behalf of the professional bodies and associations mentioned hereafter. So we will have it signed in a few minutes. And ladies and gentlemen, I take the honor of inviting the chair of Kenya Christian Professionals Forum, Mr. Kanjama. Karibu.
Thank you, George. I think I'll now be allowed to remove my face mask. COVID protocols are being observed. To the President of the Law Society of Kenya, Nelson Harvey, the Vice President, Caroline Kamende Daudi, my good friend. I forgot to say Nelson Harvey is my classmate. To the council members of the Law Society of Kenya, here present, the CEO and the members of the Secretariat, to the representatives from Kenya Christian Professionals Forum. I can see who the person we call Madam Chair, the Chair of the Advisory Council, Ann Bugwa, who's a lawyer, our Vice Chair, Alice Wainaina, who's a lawyer, and our Secretary, Vincent Kimoso, present, to the representatives of the various professional bodies who are either present here or joining us virtually, to the distinguished guests. I can see one of the champions of the new constitution, Zamba Kitonga, present, and the other very distinguished panelists, ladies and gentlemen. Good afternoon. Unfortunately, Vincent was not here to speak beforehand and introduce KCPF, so I'll shorten my remarks so that I can give him a minute to say something about Kenya Christian Professionals Forum. But I would like to say that we as professionals, we always go to a different professional groups, and sometimes we engage in a silo mentality. You do your things in your professional group, and if another professional group is having their own challenges, they deal with them. And we are thinking that it is high time for us to come together where we have cross-cutting matters of national importance, like indeed our Constitution of Kenya 2010. We also, as Christian professionals, bring together Christians from different denominations and backgrounds. And we've also found it very useful to engage with our fellow people of faith. We engage with Muslims and Hindus in several initiatives, like when we commemorate the International Day of Families on May 15th. And we are extremely delighted that the Law Society of Kenya has shown vision and leadership to come together with us to not only commemorate this 10th anniversary of the Katiba, but to champion and pioneer this proclamation of professional groups, where we are saying from this year henceforth, we shall commemorate Katiba Day on every 27th of August as professionals. We are also saying that the Constitution is, on one hand, the laws, the institutions, and the external apparatus, the text that has to do with the Constitution itself. And that one is largely in place. But on the other hand, the Constitution is the software. That is what BBI was telling us. And we are saying that this software is the values that are indicated and writ large in the document. It is the virtues that the leaders and the citizens of Kenya are meant to have. During the time of the foundation of the American federal republic or government, they had the Federalist Papers, and some of those who started the American experiment, as they called it, the constitutional experiment, they said, even if we have the best laws and institutions, we will not succeed in constitutional government unless we have virtuous people. And virtuous people are people who manifest, apply, and demonstrate good habits. And the whole, you could say, crisis of integrity, the issues of corruption, the whole crisis of inclusivity, the issues of negative ethnicity is because we as the people may not have sufficiently inculcated in ourselves these virtues and values. And the Constitution is also about the vision, the roadmap for the future. So I'd like to say that these 3 V's, the virtues, the values, and the vision, is the software that we as professionals are now saying we need to ascribe to ourselves, to demand of the leaders in our country, to demand of ourselves and of other citizens, and to spread this gospel or this message. We are delighted that our Constitution begins with reference to God. Our values are not just found in Article 10 of the Constitution, which sets out under paragraph 2, A, B, C, D, different sets of values. The preamble to the Constitution establishes several values, including the supremacy of Almighty God of all creation, the importance of the individual, family, communities, and the nation. Article 11, when it talks about our cultural foundation as a nation, establishes our values. Article 45, when it talks about the family as the fundamental group unit of society entitled to protection. And in other parts of this document, we find our values writ large. And what we are asking today is, can we as professionals, as we commit in the second phase, the second 10 years of implementation of the Katiba, as we commit to be at the forefront, can we inculcate these values? Can we promote these virtues in our own lives and in the lives of our families, our communities, and the nation, of the other individuals? And can we have this unwavering vision? Let us remember the roadmap, this unwavering vision for a better, more equitable society, sustainable for our generation and for future generations, and that we may treat all the resources in our country, our land, our environment, our public finances, and so on, as a trust that is for us and for our children. So with those few remarks, I would like to conclude by thanking all of us for being here and for joining us in this commemoration. We look forward to the discussions ahead. Please allow me to give Vincent Kimosov, the Executive Director of KCPF, 1 minute to just say what is KCPF's approach and programs. Thank you.
The President of the Law Society of Kenya, members of the Council, members of KCPF, fellow professionals, good afternoon. I think we already have good afternoon. One of the challenges that I have, Mr. President, is when given a minute to speak, because it looks tight, but I will try to comply, because we are also prudent as professionals in managing time. As my chair, Charles Kanjama, said, the Kenya Christian Professionals Forum is an ecumenical body that brings together professionals from different backgrounds who believe that by our faith, there are issues and important provisions in the constitutions that we have to be on the forefront in championing them. And some of them have been outlined, so I would actually summarize by citing relevant provisions that inspire our work. Number one is the Article 10(2) of the Constitution, our values. Article 26, which is the right to life. 32, the freedom of religion. 45, the family. And Chapter 6, which is leadership and integrity. So our programmatic organizations or our thematic focuses are based on those areas. We have different categories of members, associates, individuals, corporate, and also students, because we have to be deliberate in building and raising the next generation of people who will advance and be of great cheer or champions in these areas. We appreciate the opportunity to partner with the Law Society, and we look forward to greater engagements. That is 45 seconds. I thank you, my chair.
Thank you very much to the President of the Law Society of Kenya, Mr. Nelson Avi, the Vice President of the Law Society, Madam Caroline Kamende, the Chair of KCPF, Mr. Charles Kanjama, the council members present, the representatives from the various professional bodies, the senior members of the bar present, and ladies and gentlemen, good afternoon. My name is Caroline Mudeu, and I would like to take this opportunity to invite the representatives from the various professional bodies to make their remarks. I will start with Irene Kimashia from the Institute of Human Resource Kenya, the Executive Director. Kindly come and make your remarks in 3 minutes. Thank you.
Good afternoon, ladies and gentlemen. All protocols observed. My name is Irene Kimashia. I'm the Acting Executive Director, Institute of Human Resource Management, and we are happy to be part of this initiative. I am accompanied by my council member, Madam Catherine Mwangi, who is going to make brief remarks on behalf of the National Chairman. Madam Catherine.
Thank you so much. All protocols observed, good afternoon. Once again, I would like to introduce myself. My name is Catherine Mwangi. I'm a council member of IHRM. I just want to say something on behalf of our national chair, that once again, we are happy and delighted to be associated with you people. Thank you for thinking about this particular forum. Yes, indeed, it's a positive way forward, especially for our Katiba, so that we can be able to lead as an example. And therefore, we want to say, as a professional body from IHRM, that we are together, we will work together, and above all, we'll also be able to help you to build the capacity in all areas needed. Thank you so much. Good afternoon.
I would like to invite the President from the Institute of Engineers of Kenya, Mr. Nathaniel Matalanya, to make his remarks.
The President of the Law Society of Kenya, Advocate Nelson Avi, the Chairman of the Christian Professional Forum, Charles Kanjama, all my other presidents present from other professional societies. I also salute the former chair of the Committee of Experts and the Vice Chair, my friend Zamba Gitongo and my friend Sango Chesoni. I'm very happy to be here. My name is Nathaniel Matalanga. I'm the president of the Institution of Engineers of Kenya. I'm very happy that today I'm talking to lawyers, because we engineers think that if we have a discourse with the lawyers, all the problems of Kenya will be solved. Receive greetings from the Institution of Engineers of Kenya. The Institution of Engineers of Kenya is the landed society of the engineering profession and cooperates with national and international institutions in developing and applying engineering to the benefit of humanity. IEK has over 7,000 members drawn from engineers and technicians working in various government institutions, both national and county, and the private sector, consultants, contractors, educators, designers, and manufacturers. The Institution of Engineers of Kenya welcomes and supports the proclamation by Kenyan professionals to promote constitutional values and to commemorate Katiba Day. The gains of Kenya Constitution 2010 are huge, and the only way to appreciate this is to try and imagine where we would be as a country if the 2010 Constitution had not happened. We are aware that it's still not a perfect document, and we professionals have ourselves to blame for handing over the finishing process to politicians who gathered at the Great Rift Valley Lodge and mutilated a good document that had been prepared by the committee of experts. We now have a chance, as proclaimed by the President yesterday, to revisit the document and right the wrongs for the prosperity of our country and future generations. Chapter 4 of the Constitution, the Bill of Rights, cannot be fulfilled without the participation of engineers. Economic and social rights, such as provision of adequate housing, reasonable standards of sanitation, clean and safe water, food and of acceptable quality, and clean and healthy environment, access to information and education, are some of the few areas where if you ignore an engineer, then you're not going to get anywhere. Engineers have been key drivers in development of infrastructure and achievements, although with very many challenges and problems. We have led in the construction of over 8,000 kilometers of paved roads and the SGR from Mombasa to Naivasha, leading to improved access to services, health, and education for citizens. The Rural Access Index has risen. The Rural Access Index is defined as the percentage of the population living within 2 kilometers of roads in good condition, has improved from 52% in 2013 to 60% now. Construction of county headquarters and Huduma services for easy access to government services, improved power supply, railway development, and telecommunications. The challenges that we have experienced are the following, and we need to address this as professionals. Disparity in infrastructure development persists across the country, with inadequate water supply, power, and roads, leading to the current fight and stalemate that has occurred at the Senate over the revenue allocation. We have witnessed collapse of buildings due to lack of involvement of professionals and lack of capacity and corruption at the oversight agencies. Role of professionals, engineers, particularly at county level, to oversee design and construction has not been embraced by the county leadership. The procurement law does not differentiate procurement of goods from that of services and has relegated technical professionals to the periphery. Engineers have technical training and best qualified to lead procurement of technical services and specialized goods. Professional leadership has been diluted in key institutions as appointments of boards and chief executive officers are highly driven by political interests. Similarly, project identification, selection, or prioritization has been largely politicized without consideration to economic and social policies. The shift of power from executive and judiciary, where professionals largely reside, to the legislature is undermining the country governance and structures, the country governance structures, limiting the dream and aspirations of our citizens. Engineering projects have been the special purpose vehicle for grand corruption in several instances. You heard of the Kimwaro Dam, the National Youth Service. This has undermined performance of the nation, and we professionals need to take a firm stand on this. Some of the non-constitutional practices include constituency roads committees, in which members of parliament have executive role, resulting in low accountability in implementation of fraud work programs. We need to restore the role of technical professionals to lead technical institutions. For us to appreciate the magnitude of this problem, my fellow members, and especially I appeal to the lawyers, what's happening in the infrastructure institutions in this country can be compared to having an engineer or a medical doctor as the Chief Justice or the Attorney General. The problem is huge, and we, the professionals, need to join hands in solving it. The Institution of Engineers of Kenya supports a full implementation of the Constitution and Chapter 6 on leadership and integrity, and has enshrined these principles in the Institutions of Engineers Code of Conduct and Constitution. God bless Kenya. Thank you very much for listening to me.
Thank you very much, Engineer, for the few remarks. And also, Madam Catherine. I would like now to invite Madam Millicent Osano, the Executive Director from the Institute of Quantity Surveyors, to come and make a few remarks.
Good afternoon, everyone.
Good afternoon.
All protocols observed. My name is Millicent Osano. I'm the Executive Officer at IQSK, that is Institute of Quantity Surveyors. So on behalf of the IQSK President, QS James Munene, we just had a recent election last week. So we are proud of him. We are grateful to be here and to support it. This day in particular, the fact that it's even called Katiba Day brings it home. You know, we are proud to be Kenyan. We are proud of the Swahili national language. So without many remarks, we are grateful and we support LSK, and even in the implementation of commemoration of this day. Thank you.
Thank you very much, Madam Millicent. I would like to invite Mr. Nahashon Okowa, the chair of the Association of Construction Managers of Kenya.
Thank you very much. The President LSK, Advocate Nelson Harvey, the Chairman of Kenya CPF, Advocate Charles Kanjama, fellow chairpersons from different professional bodies, good afternoon. My name is Nashon Okoa. I am the Chairman of the Association of Construction Managers of Kenya, ACMK. We are delighted to join our colleagues in this event of marking 10 years of our Constitution. Indeed, we must be awed by the challenges we still face, but still as well moved by the sense of hope and faith we have in our country. The challenges we face are by no means insurmountable. We must draw strength from ourselves, from our tenacity to continue to demand better for our country. While change will not happen overnight, we must seek the instinctive desire for change. Our democracy simply cannot be advanced when the mindset of those with instrument of power are still with the old constitution. And my fellow colleague from Engineer Matalanga from the built environment has highlighted some challenges that we face in the construction industry. And indeed, things need to change. We are 10 years after the new constitution, and 85% of the value of our projects in this country are with foreigners. Only 15 we scramble for. In the last decade, there has been shortfalls and false starts in upholding this constitution. We have to be honest about that. let us take responsibility for our current condition if we are to obtain the will for a better constitutional dispensation tomorrow. We at SMK commit to uphold and defend this constitution and thank Kenya KCPF for bringing us together as professionals. And indeed, I support the idea that this day, we need to mark it going forward as professionals in this country, professional associations, so that we speak with one voice on these important national matters. Thank you.
Thank you very much, the representatives from the various professional bodies, for the kind remarks. We will now go to the signing of the proclamation, and it will take place at this part here. I would request my co-moderator, George Omwanza, to help with the signing of the proclamation. And at the signing, I would request we start with Madam Irene Kimashia from the Institute of the Human Resource to start with the signing. Oh, sorry, Madam Catherine Mwangi. Oh yeah, I'm told we can have two representatives sign. So in that case, I would call the Nathaniel from the Institute of Engineers. Engineer, kindly proceed also to sign. There are 2 copies, so I would request that you sign 2 copies of the same. Thank you. I now call Millicent Osano and Naashon Okoa to also proceed to sign. Mr. Charles Kanjama, kindly proceed to sign. And lastly, I would like to invite the President of the Law Society of Kenya, Mr. Nelson Avi, kindly proceed to sign. Thank you very much. And now, ladies and gentlemen, allow me to welcome the President of the Law Society of Kenya, who is our keynote speaker today, to make his speech. Thank you very much and welcome, President.
Kenyans, friends, learned friends, good afternoon. Allow me to look a little bit disorganized today, like a professor of law. They often come with so many books, articles, newspapers, the Constitution. Fortunately, mine does not have amendments like the one carried by Professor Bernard Sianya. We dedicated it this morning at the Holy Family Basilica. Why did we dedicate the Constitution? We dedicated the Constitution for the following reason. Because the preamble of the Constitution reads as follows: "We, the people of Kenya, acknowledging the supremacy of the Almighty God of all creation." Friends, today is a big day. It is Katiba Day. Though not gazetted as a public holiday, it is a day that is very important. It is important because it was a day that culminated in the promulgation of the Constitution. Let me just remind you in brief what President Mwai Kibaki was mandated by the people of Kenya to read that day. And this you will find in page 155 of the Constitution. It is called the Promulgation. It reads as follows in part. And whereas the Constitution of Kenya Amendment Act 2008 and the Constitution of Kenya Review Acts of 1997 and 2008, as variously amended, provided a legal framework for the comprehensive review and replacement of the current constitution by the people of Kenya, which ensured that the review process, and this is very important, accommodated the diversity of the Kenyan people, including socio-economic status, race, ethnicity, gender, religious faith, age, occupation, learning, persons with disabilities and disadvantaged, and was guided by respect for the universal principles of human rights, gender, equity, and democracy. B, provided the people of Kenya an opportunity to actively participate freely, meaningfully in generating and debating proposals to alter the Constitution. That, friends, was the foundation of this Constitution. Where are we now, 10 years down the line? This is where we are. As reported by the Standard, Uhuru set stage for referendum. As reported by the Star, revealed money trail that nailed Obado 4 children. As reported by the Daily Nation, Graft family loses looted NYS riches. And as reported by all the 3 dailies, a statement by the Attorney General of the Republic of Kenya, an individual, a member of this society who faces proceedings for expulsion. This is what he says. Calling on all leaders to abide by the constitutional values and principles on leadership and integrity. How sarcastic. It is sarcastic. And friends, I'm going to tell you the truth. The whole truth and nothing but the truth. If you want theories, there are teachers of law here, they will tell you theories. If you want the cost of implementation of Constitution, you have a teacher of law with distinction in economics of the Constitution. He will tell you about it. But I'm not going to tell you that. I must tell you something that must enrage you so much that you get dissatisfied like the people of Burkina Faso, that you feel you must go and set parliament ablaze. Why must you be enraged? You must be enraged because the Constitution has not been fully implemented. And 10 years, the Constitution is still a young girl. What do they want to do with her? They want to give her in marriage to old men, old women, people who do not have your vision, people who have not enabled you to actively participate, one, in a review process, two, in a drafting process. What is this Constitution that they want to amend? What is this rigidity that they see in it? Do you see rigidity in the Constitution? You know, this is what the Swahili say. Samaki mkunje angali bichi. Ukijaribu kumkunja kama amekauka, utaona rigidity. Kenyans, tell me one document, one executive order, one deed, one instrument executed by the government of the Republic of Kenya that acknowledges the supremacy of the Constitution. You'll find none. You will find none. And if you are doubting what I'm saying, pick all the executive orders signed by the President of the Republic of Kenya. Look at the transfer of the functions of Nairobi County Government. Save for a perfunctory mention of the enabling provision of the Constitution, there is no way to justify those actions. And you must be sad. Because if you don't get sad, your children, you, and you, will always lament as you have lamented today. No wonder, therefore, that it should not surprise you that in this house, in our midst, we have the makers of the Constitution. They are all here. These are the makers of the Constitution. The breakers of the Constitution are elsewhere. In the morning when we went to the Holy Family Basilica, there was nobody from the executive. There was nobody from the legislature. The judiciary was there. We were there. We the people. And I'm not going to lament that the executive did not organize a big function today. I'm not going to cry that Parliament has not deemed it fit to honor this day. I think it is good. You know why it is good? Because power abhors a vacuum. I want you to feel that vacuum today. Why must you feel that vacuum? Because certain individuals in their sunset years want to lay a foundation stone for leadership. They cannot do that. If in your sunset years you break ground to lay a foundation, you're only laying a foundation for your tomb. Do not be entombed in the foundation that is being laid by those who think the Constitution was promulgated as a ceasefire document, that the Constitution is rigid. And I say this because they don't have an insurance on me. They fought so much to ensure that I do not serve the society. But we must tell them the truth. And this is the truth and nothing but the truth. Is the Constitution ripe for amendment? What do you think? Marcy, is the Constitution ripe for amendment? Engineer Matalanga, do you think we should amend the Constitution? Millicent, do you think we should amend the Constitution? Why are you guys afraid? There are no Subarus to pick here. Speak your mind. Act. There are those who sacrificed, they fought and spoke when there was no freedom of expression. You have the freedom of expression, express it. And you must express it because the Constitution guarantees you that right. No wonder, therefore, we have a commission, the Human Rights and Equality Commission, that is supposed to cater for you, to ensure that when you speak, when you act, you're not suppressed. I think the Constitution is ripe for amendment. Sinamnayo, my friends. Let me move from Takatanga and go to Kieleweke. The Constitution is ripe for amendment. Who says no? Fine, Mwalimu, I'll tell you why the Constitution is ripe for amendment. I'm going to pick not more than 5 articles that are required amended. Okay, let's start with Article 81 of the Constitution. B says, the electoral system shall comply with the following principles: that not more than 2/3 of the members of the elective public bodies shall be of the same gender. And then what does the Constitution say in the event of failure? Let's go to 261(7). This is what the Constitution says at 261(7). If Parliament fails to enact legislation in accordance with an order under Clause 6B the Chief Justice shall advise the President to dissolve Parliament, and the President shall dissolve Parliament. What if the Chief Justice does not advise the President? What if the President does not dissolve Parliament? Zamba Gitonga, Atsango Chesoni, you are here. This part must be amended. It must have a finality. We need to know what will happen if the Chief Justice does not advise the President. It should say the Chief Justice shall henceforth be removed from office. What if the President does not dissolve Parliament? This article should be amended to read as follows: and the President shall henceforth be removed from office. Namna hiyo? Okay, a few more classes, then we close this debate. Let's look at the Judiciary Fund, Article 173. It says, Parliament shall enact legislation to provide for the regulation of the fund. What if Parliament does not do that? What if the executive fails to give money to the judiciary? This article must be amended. Higher, let's look at the appointment of judges. Article 166, appointment of Chief Justice, Deputy Chief Justice, and other judges. The President shall appoint those subject to the approval of the National Assembly. That is the Chief Justice and the Deputy Chief Justice. B, all other judges in accordance with the recommendation of the Judicial Service Commission. Zamba, what will happen if the President does not appoint them? There's a problem in the Constitution. Let me give you a few more, because our professors here should not eat our school fees. They must give us solutions today. Let's look at the role of Parliament. This is the role of the National Assembly under Article 95, Sub-Article 5A. The National Assembly reviews the conduct of the President, the Deputy President, and other state officers, and initiates the process of removing them from office. The National Assembly exercises oversight over state organs. Which state officer has been removed by the National Assembly in the last 8 years? Hands up. None. And you will find them in barazas. Mutai Kagwe must resign. Dr. Matiang'i must resign. Resign and go where? You know, these people will prefer to die than resign. Why are you making them their work difficult? Are you without recourse? The Constitution says initiate their removal. Now, what happens if they don't initiate their removal? I think they should also be removed forthwith. What about the cabinet? This is what it says. That is part 3, Article 152. The President shall nominate with the approval of the National Assembly. Sorry, the President shall nominate and with the approval of the National Assembly appoint cabinet secretaries. A cabinet secretary shall not be a member of Parliament. Okay. At one point in time, they made a member of Parliament resign and appointed him Minister of Interior. Do you remember? Riziki, were you born by that time? Do you remember? There are those assistant ministers, all of them politicians. Where is the legal framework for their appointment? The Constitution is also explicit that elective and appointive offices shall ensure compliance with the two-third gender requirement. And you know, when I say this, they say, Harvey is the new day Akuku danger. He is surrounded with 10 women, and he does not see the problem on his part. He is demanding that Parliament be dissolved. Fine. If you want the Law Society to be an arm of government, enable it. Put it in the national budget. Give us money, because we do a lot of work. But the Constitution must be implemented. There was that silo that my classmate Charles Kanjama referred to. Charles, do you know why we're in that silo? Engineer Matalanga, tell me how many engineers are in the National Assembly? In the Senate? In the Cabinet? Good. Catherine Mwangi, how many of your members are in the National Assembly, Senate, and Cabinet? None. Good. Millicent Osano, how many of your members are in the National Assembly, Senate, and Cabinet? One. Okay. National Core, how many of your members are in the National Assembly, Senate, and Cabinet? One. Okay. Fine. Who do we blame? Who elected these members of the National Assembly? Who elected members of the Senate? Who elected the President of the Republic of Kenya? You. You ladies. And here you are making noise. We have not attained two-third gender rule. Often, they'll beguile you, give you some ladies who in actual fact are men, because they support patrimony. They steal with them. They implement bad policies with them. Then you come and tell us you've elected women. You come and tell us that women have been appointed in cabinet. There is a problem. Let me close this. At no one point in time in life have wolves been led by sheep. You cannot claim to be wolves, yet every day, 5 years, you elect sheep to lead you. Friends, Nathaniel, Millicent, Nashon, and Charles, I want you in the National Assembly. I want you in the Senate. And if I have the power, I will also appoint you in the cabinet. You see, there is a sentence that you can write. Opportunity is now here. If you read it keenly, it also reads as follows. Opportunity is nowhere. Obstacles are the things you see when you remove your eye from the target. Let me not bore you with my statements. Maybe a Subaru is waiting for me. I better close. Let us always celebrate Katiba Day. Let it count for something. Because if it does not count for something, it will be for nothing. We did not labor for the last 30 years for the Constitution to count for nothing. Friends, thank you so much. God bless you. God bless Kenya. God bless the Constitution. Mungu aibariki Katiba na Katiba Day. Asanteni sana.
Wow. Thank you, President Nelson Harvey, for the great remarks that have kick-started our commemoration debate today. Before we move to the second session, where we are going to have panel discussions moderated by Duncan Okubasu and Nedi Akelo, allow me to express our sincere appreciation to all the professional bodies that have joined us today, that have signed and committed to upholding the rule of law, and requested Kenyans of goodwill to join us in celebrating every year today as Katiba Day. To allow us to move to the next session, and as our panelists prepare to join us, allow us to have a brief photo session, and so that the president can get an opportunity to display to Kenyans the proclamation that has just been signed by the professional bodies here with us. I'll request the president, the vice president, and council members to just one step down and be joined by the leaders of the professional bodies with us here. We'll have one line down and then the other one on top. Any other leaders of professional bodies that have joined as you are going on, please also feel free to join. You'll also get an opportunity to sign the proclamation. The professional bodies that did not make it today, there are several that have expressed their willingness to join. We'll avail the document for your signing in due course. As they arrange to take the photo, I'll just read the proclamation so that Kenyans who have joined us can know what the professional bodies have committed themselves to do from today. And it reads, "We, the professionals in different professional bodies and associations in Kenya, acknowledging the supremacy of the Almighty God of creation, His leadership over our country, its laws and people, honoring the Constitution of Kenya 2010, its promulgation on 27th August 2010, and its continued direction and guidance in our beloved country, Kenya, over the last 10 years. Committed to upholding and defend the Constitution of Kenya 2010, as well as to nurture and protect the well-being of the individual, the family, communities, and the nation. Careful that as a nation, we have achieved this milestone of recognizing 10 years since the promulgation of the Constitution of Kenya 2010 on 27th August 2010. Now, therefore, we, the professionals in different professional bodies in Kenya, in commemorating the promulgation of the Constitution of Kenya 2010, wish to have 27th August be marked as the Constitutional Day, that is Katiba Day, by all professionals and Kenyans of goodwill. We hereby commit to recognize and appreciate the said promulgation every year and to uphold the spirit and letter of the Constitution of Kenya 2010. We also commit to recognize and promote our national values and principles of governance, our cultural foundation as a nation, and the family as the natural and fundamental unit of society, as enshrined in the Constitution, and advocate to have them upheld and defended in our beloved country, Kenya. This proclamation does not intend to mark or set aside 27th August as a public holiday. In witness wherefore, we have unto set our hands 27th August 2020 on behalf of the professional bodies and association. May we have applause? Thank you. Thank you, professional bodies leaders. Thank you, Kenyans, for the great opportunity that you've given these leaders to serve you in various positions. I will now call upon Nedi, and Duncan to join us. as well as our panelists. As they take their seats, our moderators today, Duncan Okubasu is an advocate of the High Court of Kenya and lecturer, public law, Moi University. Madam Nedi Akelo is managing partner, strategy, Mamras Sitakas, Advocates LLP. We are going to be joined by our moderators, Senior Counsel Nzamba Kitonga. If you may take your seat. Madam Atsango Chesoni, Dr. Jaramba, Kamodho Waiganjo, Nedi and Okubasu, you may take over.
Thank you, our CEO, Madam Masiwambua. The presidents in the house today, the president of the Law Society of Kenya, all protocols observed. Good afternoon. I welcome you to the second session of today's Katiba Day. This is where we will be analyzing, criticizing, dissecting, literally looking at the constitution that we promulgated 10 years ago today. The panelists include the chairman, the former chairman of the COE, Mr. Nzamba Kitonga, Senior Counsel, the vice chair, Madam Atsango Chesoni, Dr. Njaramba Gishuki, our distinguished scholar, Mr. Kamodho Waiganjo, and finally, Ms. Roslyn Odede will be joining us via video conference online, and I will introduce them one at a time. To start with, I'll start with Mr. Nzamba Kitonga. Mr. Nzamba Kitonga requires no introduction, really. He's a long-time, many-time president and chairman of many panels, institutions, constitutions, and implementation bodies that we have seen many years over. Mr. Nzamba Kitonga served in the Council of the Law Society of Kenya, where he was the chairman of the Law Society of Kenya in the year 1997. During his time as chair, he not only led the stabilization of the society, but he's also credited with overseeing one of the most productive periods in the law society. Mr. Nzamba Kitonga, as I said, is a president of many times over. We've seen him as the former president of the East African Law Society. He has been the president of the COMESA Court of Justice. He has been the chairman. He's currently practicing law in his law firm as the managing partner, and he's also the UN Genocide Trial Monitor. Most recently, he was the chairman of the committee of experts that ushered in the new constitution that we call the Constitution of Kenya today. Mr. Nzamba Kitonga has been and continues to be a good voice of authority on constitutional matters in Kenya. Next to Mr. Nzamba Kitonga is Mr. Kamodho Waiganjo. Mr. Kamodho Waiganjo wears many hats. My former lecturer, I say that with a lot of pleasure because he has brought me to where I am today. Typically, he would be what we would loosely refer to as a jack of all trades, but distinguished and learned in all of them. Mr. Kamodho Waiganjo is a senior partner at Seth Waiganjo and Associates. He's a constitutional lawyer and was most recently renowned for his tenure as a commissioner in the Commission on the Implementation of the Constitution, where he was the chair of the Public Finance Committee, and he also co-convened the Devolution Committee. He's also a newspaper columnist, where he has written and continues to write on topical issues. He is further renowned as a commercial and conveyancing lawyer with more than 20 years practice to date. Other areas of his expertise include public law and procurement, alternative dispute resolution, and international trade law. As a senior conveyancing lawyer, he has been and was the convener of the Law Society's Conveyancing and Property Law Committee for quite a number of years. He's also been a long-serving member of the Council of the Law Society and is a chartered arbitrator. As I said, he wears many hats, but again, does not falter in any of them. Next to Mr. Kamotho Waiganjo is Dr. Jaramba Gishuki, our in-house distinguished scholar, of course of many years. Dr. Jaramba Gishuki is a scholar and an advocate of the High Court of Kenya, an active practitioner of law. He lectures at the University of Nairobi. He's a member of the Commercial Law Department of the university, where he teaches law and development, as well as securities law, among others. He's an author, and currently he's the coordinator of the postgraduate studies at the Faculty of Law at the University of Nairobi. He's a senior researcher and also an associate at the Strengthening Human Rights Research and Education in Sub-Saharan Africa. We cannot stop by saying he holds an not just an LLB and an LLM, but equally a PhD in law. The person I'll introduce next, of course, my former vice chair, who I'll let take her seat as I introduce her. Madam Atsango Chesoni is a passionate defender of the Constitution and of rights, more particularly women's rights, but generally all rights in the Republic of Kenya and far over. Ms. Chesoni is a lawyer who has worked with the Federation of Women Lawyers in Kenya, FIDA. She was initiated in, where she initiated the annual status of the Women's Human Rights Report. Ms. Chesoni has spent years consulting the civil society in Kenya, both within the region and outside. She has focused her consultations on governance, on human rights, including women's human rights, and also on the law. She was nominated by the African Women Development and the Communications Network, FEMNET, to represent the women's movement in the constitutional negotiation in the former process of the constitutional analysis called the Bomas process, which looked at the longer discourse of the constitutional making in Kenya. More recently, she has served and was the vice chairperson of the Committee of Experts, which ushered in the new constitution that was promulgated in 2010 that we commemorate today. Finally, our fifth panelist, who is joining us online and is not with us here physically today, is Ms. Roslyn Odede. Ms. Roslyn Odede is our own in-house pro bono expert. Ms. Odede is an advocate of the High Court of Kenya with more than 20 years experience in legal practice and strategic leadership in various professional organizations. She currently practices as a certified professional mediator and an independent legal consultant. Her practice areas include gender, elections, governance, environmental impact assessments and audits, employment law, law compliance audits, family law, commercial arbitration, and mediation. She is also a member of the African Union Commission panel of experts, and she has been a council member of the Law Society of Kenya. She has also been a council member of the East African Law Society and of Commonwealth Lawyers Association, where she also served as on the Council of Legal Education as the vice chairperson of the Judges and Magistrates Vetting Board, and currently is a council member of FIDA Kenya, the Federation of Kenya Women Lawyers. Roslyn is passionate about community service. For over 15 years, she has offered pro bono legal services for gender and family law related issues in the North Rift. Ms. Odede was recently awarded with an East African Law Society recognition for being a distinguished legal service provider and also a head of state commendation in the civil division by His Excellency the President of Kenya for offering pro bono legal services. Roslyn Odede is a founder member and a past chair of the Eldoret Hospice Board, which is a charity, and is also a honorary legal counsel for the Kenya Medical Association in South Africa. Finally, she holds an LLB degree from the University of Nairobi and is a member of the Chartered Institution of Arbitrators and is a certified mediator. Members of today's discussion, I welcome you to the panel discussion on where we are today in promulgating the Constitution 10 years on. Our President, Nelson Harvey, has laid a good foundation for this discussion, and I welcome you to the discussion today. All questions can be forwarded to the online platform, and the panelists can be sure to address them all. Welcome.
Okay, thank you very much.
Let me invite my co-moderator to start us off, Mr. Duncan Okubasu.
Thank you very much, Neddy. I'll operate from where I am here. I'll sit here and set out the questions. Now, I'll start with the former chair of the committee of experts that participated in negotiating and writing this constitution that we have come here to celebrate. I have a question specifically for you, and which will also go to Atsango here, seated next to me. And the question is that when you sat down to write the constitution, and then it was taken through a referendum, and it turned out to be a success. The referendum basically passed the document. And seated where you are now, 10 years down the line, would you say that the constitution that you participated in writing lived up to your expectations?
At this forum, and let me appreciate with you this day on which we commemorate the passage of the Constitution. Let us also appreciate people and persons who died and lost their lives or their property in this long journey. Let us also on this day be appreciating those people because they died for us. Now, to answer the question, I think there has been much progress in terms of implementation of the Constitution. In particular, during the term of office of the former Attorney General, he did endeavor as much as possible to ensure that the laws that were required to be amended or reenacted were done. But this aspect has lost steam in the last 5 years because in actual fact we were supposed to amend or reenact about 540 pieces of legislation. By the time Gideon Muigai left office, only about 50 to 100 had been reenacted. So we need to make this process quicker because in the last three or so years, we have had a situation where the reenactment of laws or amendment has been haphazard and lax. My recommendation would be that we speed up this process. On the other hand, in terms of implementation of the Constitution, devolution has been quite a success, although it has had its own pitfalls in terms of mismanagement, in terms of corruption. But we cannot blame the Constitution on this. It is us as Kenyans who have elected leaders, and therefore we must also share the blame. So from where I sit right now, I think there has been good progress. Some things could have been done in a better way. For example, the appointment of judges has disappointed Kenyans because up to now, we have not had the 41 judges appointed so far. There has been disobedience of court orders by the government. These are things that could be done better. So there has been the good and the bad, and we should be able to endeavor to achieve much more.
So if I get you right, you say the Constitution has lived up to your expectations?
Yes. But things could have been better.
Things would have been better.
Yes.
Perhaps, Sango, your views about whether the Constitution that you participated in writing has lived up to your own expectations?
Thanking the Law Society of Kenya and the Kenya Christian Professionals Forum for having set up this forum today, and to say that I greatly appreciate you having done so. All protocols observed. I think there have been areas of the Constitution which are self-executing and which therefore nobody could interfere with. In respect of that, I think the Constitution has lived up to our expectations. What am I referring to? For example, until 2010, Kenyan women were not citizens. Under the Constitution, we are all citizens. So that's not something anyone could tamper with. I concur with Zamba pretty much in terms of what he has said. Where we have tended to experience challenges are areas where I think are a threat to the political elite and the existing political order that we had. And so there has been resistance in respect of certain areas of implementation, particularly in relation to the provisions in relation to integrity. We saw the enactment of legislation or interpretation of the Constitution in ways that were inconceivable in relation to some of those types of provisions. And so I think in relation to those kinds of areas of the Constitution, in relation to the 2/3 gender principle again, which I believe we have experienced resistance because of the lack of political will to implement that provision. And of course, the kind of resistance that we see through the outright disobedience of court orders, which is a violation of the principle of the rule of law. And so we have experienced challenges in those types of areas. There were also areas which were pleasant surprises. For example, when the Constitution was first promulgated, there was an attempt to appoint, if you recollect, the Attorney General in a manner that was not consistent with the Constitution. And we saw even people who were conservatives, who may have stood to benefit directly from these types of actions, standing up and saying, no, you can't do that. You know, we have a new Constitution. The Constitution says this is how you go about these kinds of processes. So there have been areas where the Constitution itself has lived up more
to its expectations.
Yeah. One of the areas which I just want to mention, as you know, also I feel has been a gain, which I didn't think we would realize the gains within so quickly, was devolution, despite all the problems that we have faced. And I think there are challenges, but I didn't realize how quickly the impact of having a devolved system would be felt in a positive sense.
So in your final assessment, you say that looking back, you think the Constitution has lived up to your expectations of what it would do?
The Constitution itself has lived up to my expectations. Sadly, we have also discovered that there are new ways of avoiding the principles that we had attempted to enshrine.
Okay, thank you very much. Maybe I get to Kamodo, who was part of the people that were implementing or enforcing the Constitution, as it were. And we know that the tenure or the term limit that had been set by the Constitution for the existence of the Commission was really short. When you reflect about it, and as you answer the question whether the Constitution has lived up to the expectations of its drafters, would you think that the term of the CIC ought to have been extended more, perhaps?
Thank you, and good afternoon. A couple of comments. I think there are certain areas in which the Constitution has delivered. in ways that were unimaginable before 2010. And I think one always has to have that context as you look into the positive side of the Constitution. There's no question that there is a lot more civic awareness in terms of people's rights, the obligations of government, the demands that people make. There's a lot more awareness across the country. Even if that awareness and the civic action does not always produce the results you want, at least there's no question the citizens understand that government owes them certain things and certain obligations. There's no question, for all the challenges in government, there's no question that there's more transparency. Not necessarily that government comes here, want it, even if it comes kicking and screaming, people know. You know, when things go wrong, people know. There are sufficient independent bodies that produce reports and the information is there. In fact, I think a lot of times the laziness of Kenyans to read these reports, you know, to just see the extent of sometimes the rot and sometimes of the good things. I think there's more equity in terms of distribution of resources. If you remember the old days of Siasa Mbaya, Maisha Mbaya, where it's an executive and the presidents that determined how resources went around the country. There is a difference. Even the fight in the Senate now is because that decision is not a decision of the executive. It's a more democratized decision. There was a survey done in 2015, 2016, I think it's called the Kenya Integrated Household Budget Survey, and it said that between independence and 2016, the largest increase in the improvement of household, reduction of household poverty was since the introduction of devolution, and that tells you that there are certain things that went right. Now, there's a lot that went wrong, and now which takes me back to your question about the CIC. From the time that the commission left office after 5 years and the time that this government came into power, the Constitution is an orphan in the sense that it does not have any institution whose responsibility is to oversee its implementation. And so it is no longer the focus of Kenyans as a solution to Kenya's problems. We now think that the solution to Kenya's problems is a change in government, or a change in the president, or a change in, we have refocused from the fact that we had understood that what was going to be the change factor was the Constitution. At that time, there was even a Ministry of Justice and Constitutional Affairs. It is not there, which means even at a governmental level, there is nobody whose responsibility at cabinet level, at government level, is to oversee and give national reports on the implementation process. So in a sense, the national focus on implementation is not there. And when it happens because sometimes, you know, we have no options. And what the danger of that is that when there are violations, then Kenyans have started to accept those violations and as part of what defines this nation. If I was rewriting the Constitution again, we would have extended the term, maybe even change the members of the commission. But because the Constitution gave that responsibility to Parliament, and inevitably, whichever commission was going to be there, to be effective, it was going to have runnings with Parliament. There was no way Parliament was going to extend that term. In fact, I remember the first thing that Parliament told us when we had our first run-in with them, I think on the second year, is we will not extend our term. And in fact, we wrote to them in writing and told them we would not seek extension. So we put that aside so that we can discuss issues without that being a threat. I think looking back, it would have been useful because what it would have done is made sure that every month there's an institution that in a sense, analyzes where we are at with the Constitution and tells Kenyans, these are the violators, this is where the violations are happening, this is what is going right and this is what is going wrong. So I think that is something that we could have done differently. But I don't think that that means that that is the end of the ownership of the oversight process. I think that process then needed to have moved to institutions like ourselves, the Law Society and other professional bodies, to own that space and to recognize that it is not in the interest of governments to implement progressive constitutions. And so we shouldn't be surprised that governments are not owners of the implementation process, and that process needs a new owner of professional bodies and other non-state actor bodies, the media, churches, if we truly believe that this constitution is transformative.
Okay, thank you very much. And perhaps, Dr. Njaramba, what disappointments do you have, if any, on the Constitution and whether it has lived up to your expectations?
Good afternoon, and thank you for having me here today. Now, I'll put it this way. when I look at the Constitution of Kenya, just like the other constitution, I would look at it from two perspectives. Number one, what value does it add to Ajiko? And number two, does the structure and the provisions, are there structures for purposes of efficiency? Now, when I look at it in that manner, I will ask myself, the many institutions that we have in the Constitution, are they giving our Ajiko value for her money? And number two, are they structured in such a manner that we can say that they are operating efficiently? And when I look at those two, of course, I have a challenge in saying that it lives up to the expectation. Of course, I'm alive to the fact that there is no perfect document. And I'll give illustrations. For example, I will say this. When we have so many constitutional commissions like we have today, and then we ask Wajiko, what is it that has come to you as a result of these commissions that we have, whether it is about your human rights, whether it's about anything else. And Wajiko, you definitely say that actually he even forgot that they existed, because when she needed them, they were not there. And therefore the question then is, why is my taxpayer, my tax as a taxpayer, going to finance so many institutions that really are not adding value to my life? Number two, I look at efficiency and ask myself, when, for example, we had the current issue about resource allocation, and we ask ourselves, what is the purpose of having, for example, the Commission on Revenue Allocation coming up with a formula? Then we take it to the Senate, and then, of course, it goes through that whole process. Now, what is the safeguard that we have, or we were supposed to have in the Constitution, to ensure that at least there is some certainty, to ensure that there is efficiency in the way these institutions operate between themselves, with a view to ensuring that at least whatever is happening is happening efficiently. And we can go on and on with the illustrations. But one thing that we can agree on, that since independence, the major problem that we have had in this country that is still there today is impunity. And therefore, if impunity has been with us since independence to date, and then I ask the question, has our constitution today lived up to the expectation that it deals with this particular problem? And the answer, according to me, in my view, is that it has not dealt with that problem. That it may have dealt with, of course, many other issues, and there are very many good things about the constitution that we have today. But on that age-old problem of impunity, really, we still have that challenge. And therefore, I'll get to the point of saying that it is good. The Constitution has provisions. But what happens if we do not implement what is in it? Because, of course, there was the idea that we can be able to deal with matters impunity with so many institutions that are in that Constitution. So what happens if those institutions are not performing what they were supposed to do? And therefore, our Ajiko is still there, waiting for the goodies, waiting for those good things that were supposed to come from the Constitution. He can't get those good things. She can't get those good things, and therefore she wonders actually, was it worth it? And therefore, that is for me the major issue, that down there we really haven't seen it going down there. Of course, there are the many good things, but there is still a challenge with dealing with impunity in the current constitutional order, as we have had since independence.
Thank you very much, Dr. Njaramba. I'll ask my colleague Nedi to ask our panelists the next set of questions.
Thank you. So, now that we are on the implementation agenda, I want us to look at the evolution of the implementation process. We have heard from all of you how it has either lived or not lived up to your expectations, of course. And now that, one thing for sure, since the promulgation of this constitution, it has not been amended, which again goes to say a lot compared to its predecessor, our independence constitution, which had a lot of, basically very many amendments, even right after it was enacted. Now, I would look at it in terms of the transitional process. From where we promulgated it up to where we are today, would you say that there has been a phase of us having lived the transitional process the way it was in the letter of the Constitution. And for example, certain changes like the provincial administration being extended, or for example, the appointment of assistant cabinet secretaries in the context of Kenya versus what is in the letter of the Constitution. Would you say that we are living up and we are actually evolving in the Constitution in the right direction? Further on, we have also noted the legislative interventions. 50 to 100 pieces of legislation versus 530-something that we are supposed to have implemented by now. What is going wrong? Why haven't we come up with all these enactments so far? We have power struggles and we are seeing everybody clamoring for amendments or not, and that this is a work in progress. I would like to hear your views on probably the evolution process, the evolution journey. I'll start with you, Mr. Kamotho Waiganjo. Having come from CIC and looked into the implementation process quite significantly, how are you looking at this evolution journey?
Thanks. The way that the Constitution had designed the implementation process was that the first phase of that process was going to be the passage of laws to facilitate implementation. And there were very strict timelines which even threatened the possibility of disbanding Parliament if the laws were not passed. I would probably give Parliament and the institutions responsible for that process an A, because the reality is that 90%, maybe 95% of the implementing laws were passed within the appropriate time. Then, of course, at the same time, we were also supposed to be institution building. And again, there were timelines for each of those institutions that were required by the Constitution. Whether we are talking about the constitutional commissions, whether we are talking about devolution itself, the new cabinet, the legislatures, those institutions were set up within the timeline that were required. The truth of the matter is that beyond there, in terms of then giving them life, what I think it's Charles Kajama who called the software, I think while we invested a lot in the hardware, in terms of the software and ensuring that those institutions obtained and reached the objectives for which they were set, I think there were failures. So that even if you take the constitutional commissions, which my brother has talked about, the truth of the matter, in terms of expectations of what they were delivered to the citizenry, I think over time, there's been a loss of focus. So the investment in form was very good. I think the investment on the software was not as strong. The fact that there have been no amendments to the Constitution is not because of lack of trying. I think by the time we left the Commission, I think there had been about 8 or 9 proposals for amendments. The only problem is that the threshold for amendment of the Constitution is much higher than the Independence Constitution. If we had had the same threshold, I guarantee you those amendments would have been made. In fact, if I'm not wrong, I think 5 or 6 of the amendments proposed to empower Parliament further. Of course, because it is Parliament making attempts to change the Constitution. The judiciary also was very effective, because I do know that it stopped one proposed amendment even before it was taken for debate and passage. So the truth of the matter is there has been attempts to challenge some of the more progressive components of the Constitution. What has helped is the Constitution's, the strength of the Constitution itself, as opposed to a commitment to not amend. And I would not be surprised that in the next year or two, if the political establishment makes a definite commitment to make amendments, except for the protected amendments which require referendum, a lot of those amendments will come. And my last point is on legislation. While I said that most of the legislation, the required legislation was passed within term, the negative side about it is that a lot of legislation was also passed with clawback provisions, which were anti-constitutional. And I know the Law Society and other institutions have had opportunity to challenge that legislation in court. And fortunately, the court has been fairly progressive in declaring a lot of those unconstitutional. So our journey has had ups and downs, steps and starts and stops. But I think on the whole, there's a lot to be done in terms of giving life to the form that we have put together. I think that is where the challenge of the next 10 years needs to be.
Thank you. That's very informative. Mr. Chairman, in the same line and in the evolution of the implementation of the Constitution, the fact that our threshold is that high, and given the fact that we're seeing new institutions that are not necessarily in the letter of the Constitution, we have chiefs continuing in place today. in the provincial administration. We have assistant cabinet secretaries, for example, who are not particularly provided for in the constitution. Would you say that we are going through amendments of this constitution in a backdoor kind of way?
Thank you very much. Let me say this in relation to the position of Cabinet Chief Administrative Secretary. We have a case in court right now where we are challenging the constitutionality of that position because it was not envisaged in the Constitution. The Constitution created position of Cabinet Secretary and thereafter Principal Secretary. It did not envisage that there would be somebody above the Principal Secretary who would even have a constitutional hierarchy. That is not within the Constitution. On the issue of the provincial administration, what the government did, or the executive rather, or parliament, did is to really re-Christian that position. So it is the same provincial administration, but with new names. Like you have, are they called coordinator, district coordinator, assistant district coordinator? That was not also envisaged in the Constitution. I think the bigger problem, the bigger picture is this, that the implementation process does not have proper leadership. That is like Kamodo has said, it is like it has been left to everybody else other than the government itself. Because we have a body called the Law Reform Commission. That body nowadays is unheard of. It is a body that is supposed to be a key cog in amendment of laws or in reenactment of laws to comply with the Constitution. We have the office of the AG, who is part of the process. Then we have Parliament, which also guides the process. But in addition to that, we have other players. We have the Law Society of Kenya. The Law Society has a role, particularly in legislation that guides litigation in this country. For example, the Civil Procedure Code has not been amended. Criminal Procedure Code has not been amended. The Penal Code has not been amended. Even the Public Health Act, which is now guiding the pandemic, has never been amended. So yes, we need leadership in this process so that the implementation process can continue.
Very well. Much appreciated. Madam Matsango, maybe as you give us your views on the evolution of the implementation process, you can weigh in on what the general feeling would be. Do we respect the Constitution enough? When it comes to matters like this that are still in court that have no, well, we have not seen them being concluded for a long period of time. We also have a number of legislation that have been declared unconstitutional and a lot of legislation that have not yet been enacted as per the law and as per what should have been. We have a very thorny issue in something like the recall clause. We have had a lot of people, the Wanjiko, saying they want to recall their MPs, but there is no legislation that enables them to do that. What is your take in that evolution? How would you weigh in on that?
Okay, I would just like to begin by going back to something that Kamodo had raised and just give you a little historical fact. When you look, as you know, the Constitution of Kenya 2010 is the child of 3 drafts. And when you look at the draft that the CKRC, the Constitution of Kenya Review Commission, came up with, the draft that came out of the Bomas Conference, and when you the proposed new constitution, which was the one that was rejected at the referendum in 2005, you will notice that there was provision for a constitutional implementation body. That body was actually originally meant to have been the CKRC itself converting into the implementation body. That clause was resisted by the parliamentarians. In order for us to negotiate as COE, in order for us to negotiate the existence of the commission, the Commission on the Implementation of the Constitution, we actually had to say that we were not going to serve on it. So you can see that there was a deliberate attempt on the political elite's part to orphan the implementation, the implementation of the Constitution. And it's interesting to me to hear that from Kamodo that the CIC then promised that they would not seek an extension. Yet the Constitution allowed for an extension. So if there was the political will to ensure the continuation of an organ that would ensure fidelity to the Constitution. All the tools that were necessary for that were actually available in the Constitution. And what it points to is the question of political will. And I think that the main challenge that we are facing with the Constitution in terms of its implementation is actually a challenge that emanates from the political elite. My position today is that the single greatest threat to a creation of a culture of constitutionalism in Kenya is actually Kenya's political elite. We have a political elite that does not believe in the rule of law, and therefore expresses this in different ways. The other challenge that we face, and which would not have been possible to envisage at the time that the Constitution itself was being drafted, because until 2010, we had a problem with the law itself. There was a problem with the law. We had a law that allowed for all sorts of egregious violations. At that time, therefore, we thought we needed to reform our institutions. We now have the institutional framework. But one of the things that we have learned, or at least I personally have learned, is that it's not enough to have strong institutions existing in law. Who you put in those institutions matters. And so one of the other challenges that we have to come to terms with, I think, as people, is who are the kind of people that are populating the institutions? Who are we entrusting with the responsibility of implementing these provisions, especially because they're so young? And I think where we have had committed personnel in the institutions, those are the areas where we've seen more success than in the areas where we've had challenges. So I think we have to understand as the citizenry that there is this contestation between our vision of the country we want and the kind of people, particularly the people we elect with all due respect into public office, who by nature of their office get to preside over how things are instituted. And so we must begin to evolve a way to have a new culture, a new political culture in this country. Kenya's political culture is not in keeping with the vision of the Constitution. And it is not one, if it is allowed to continue, that will enable the realization of the Constitution as it exists.
Thank you.
Thank you.
Dr. Njaramba, maybe just to hear you on this as well, the theory versus the practice. We have been told we have a very good document, lauded the world over. The implementation, on the other hand, this is what we're faced with today. The institutions, do you think the institutions are undermining the letter and the context of the draft of the Constitution? Again, when it comes to institutions that have been put in place, all the commissions, all the bodies that have been charged with implementing of the Constitution, how do you think that affects the draft of the Constitution, and what do you think would be a way forward for us as a country?
Thank you. The way I see it is that the implementation of the Constitution has just been mechanical. That the Constitution says that we have this institution, and then mechanically we put up the institution. And that has been the challenge that we have. That's why I would say it's the same old problem of a constitution without constitutionalism. And the challenge we have had as a country is that we expect that a third element of constitutionalism to come from the lead from the political class. But it isn't so. It is on the ordinary mwananchi to actually force it to happen. Indeed, for the simple reason that if we expect the political class to lead the way in that, then it will not do so. And therefore, it is on Wajiko to force the political class to come up with proper ways of implementing. And I dare say that the challenge or the problem has been there because Kenyans are not and have not been sufficiently ugly. You see, by sufficiently ugly meaning that when things go wrong, we are too quick to forget. We are too quick to move on to the next thing that comes up. And therefore, for me, the way forward, as you have rightly asked, is perhaps one way or the other, Kenyans to be properly and sufficiently agree on the matters of failure to implement the constitution, and that is the only way we can be able to move to the next level. Because a mechanical implementation of the constitution will not change the lives of Kenyans. It will not make things different, because we may have a very good document. We may have institutions listed there. But then if they are not learning as they should, if they are not adding value to our lives, then we have a reason to say that things cannot remain the same. And that is the way forward, because it is not the political class that will change the way we live. It is the ordinary person to ensure that you play your role so that now we force the change that we desire, the change we deserve. Thank you.
Welcome. I think that is very leading, and we'll come back to it on whether we are angry enough and whether we even know about the Constitution as the major part of the country. But for now, Okubasu, do you think we should talk about the money issues?
Money issues. And I want to ask a question to the chair and vice chair of the committee of experts. One of the concerns that have been raised over the years with successive, the first terms Uhuru government and even the second one, has been that it's exceedingly expensive to implement this constitution. In fact, at some point the government cried out that the wage bill is too high. And part of the reason for this is that when you sat down with your team to draft a constitution, you created a host of institutions, including, for instance, 47 county governments. These 47 county governments have the 47 county executive and 47 county assemblies. The number of individuals that populate these bodies are really, it's quite a huge number. And therefore the country spends quite a lot of money to pay salaries that were initially, not being paid before the 2010 Constitution. So the question that I have to you more directly for the chair and the vice is, do you regret that you imposed an expensive constitution on Kenyans? Chairman.
A negotiated document. If you look at the constitution right from Bomas all the way to Kilifi, they are designed like 14 regional governments. But when it came to the negotiations of the 2010 constitution, it was determined by the political class. This was not the committee of experts. It was determined by the committee, by the political class, that all districts existing as at 1992, during the Moi era, become counties. And this is where the problem started. Because now, once you have that kind of structure, you also have to have government structures like the assembly with MCAs, you have to have executives with ministers, and that becomes a very bloated government. I agree with you. But it is something that we could not do because the political class had already determined that that must happen. In retrospect, I think we could have done something better. We would probably maybe have thought of a regional government structure. Maybe we would have said that we would have only 14 assemblies and 14 executive governments. It is something that has come to haunt us because even apart from the salary wage bill, the resources that have been taken to counties have been wasted in very many ways. There is a lot of corruption, there is mismanagement. So it is something we need to focus on, realizing that it was a mistake by the political class, which we had to cope with. But it is something that Kenyans need to reflect as we go forward to see what we can do.
Thank you very much. So you mean your hands were really tied and there's really nothing that you could do about it. But I don't know, your views, Atsango.
The things that I really enjoyed about today's forum, and there's a profession which I wish we had present. You know, I understood from the opening, from the remarks in the earlier session, that there were other professionals that were meant to be here. I wish my economist sisters and brothers were here. I'm a great believer in interdisciplinary approaches. And one of the questions I'd like to ask us is whether or not it is actually true that the Constitution is extremely expensive to implement. I say so because on the one hand, we hear that the Constitution is expensive to implement, and yet there are all these unconstitutional parallel bodies and offices created that somehow monies can be found for. Yet monies are not found for the bodies that the law and offices and institutions that the law requires be in office. So for me, it is a false, how do I put it? It's a paper, yes, it's a false narrative. And this work began before the Constitution even was implemented, or before the Constitution was even passed. There are all these straw men that were created. Straw men like the army of dwarfs that was going to invade Kenya, because they were adults who looked like they were over 8 years old. And so you'd see resistance, you know? Straw men like the one that said the Constitution was going to allow abortion. Yet the old Constitution was silent on the question of abortion. And so you could have interpreted, it actually was more open, you know? And so this is one of the numerous straw men, the very expensive Constitution. If the Constitution is so expensive to implement, then focus on the things which you must by law have in place before you start complaining about it being too expensive. We have a whole set of parallel institutions running side by side. There is no need under the new Constitution to have a cabinet secretary for lands. We have a national commission, we have a National Land Commission. Why do we need a cabinet secretary for lands? I say it with the greatest respect, and it's nothing to do with a dislike of the particular office, but to me it's a superfluous office. Mm-hmm. And so I think that that's what is going on with the question of cost. And then I would like to also be very clear that this dress of Wanjiku's, Wanjiku decided herself that she wanted a Versace, because the views of Wanjiku were collected by the CKRC. Most of these bodies, in fact, COE cut out several commissions that were in the Boma's draft. And so you had more bodies, actually, under the Boma's draft than you do under the Constitution of Kenya 2010. And so, you know, let us remember that Wanjiku created that, that dress, and that monarchy and despotism can be cheap in a sense if you were to look at it on the surface. After all, you're just funding one man. It usually is one man. Yeah.
Okay, so can I make a comment on that issue?
Yes, I was actually coming to you.
Yeah, it's an unfortunate narrative that was very strong, particularly by some portion of the executive and parliament in the first term. And the parliament even set up an institution. I don't know whether any of you followed. There was something called the social audit of the Constitution that was chaired by the Auditor General. And there's a report. By the way, that committee went into that process believing the Constitution was expensive. By the end of it, they concluded, and Kenyans should read that report, they concluded the problem is that we have not implemented the Constitution properly. Because we have a lot of parallel institutions. Is it called the National Government Coordination Act? It requires that the entire mechanism of the provincial administration stays. So the sub-chief, the assistant chief, the chief, all those people stay there, even though you also have a parallel administrative structure by the county government. So the problem is not with and that was a report that I think Kenya should read. Number two, we forget that before this constitution, we had 200 plus local authorities, which were dissolved. There was a cost there. We had 200 districts. I think there were 250, dissolved. We had 14 provincial administration, working groups. Again, most of those should have been dissolved or at least reduced, even if government still wanted to retain the presence. We also have retained a lot of the workers, even on the devolved functions. We still have a huge bureaucracy in the Ministry of Health, even if 95% of health is devolved. Parastatos, has anyone looked at the number of parastatos we have? How many of those parastatos make sense in a devolved system? In agriculture, which is devolved other than, I think, policy, we still have about, 50 parastatos? In fact, the ones that were consolidated in the AFA Act, and I think lawyers need to read these issues, the ones that were consolidated, there's now a proposal to break that act so that you have the differential institutions, the crops, whatever parastato, the whatever parastato. There's a proposal to undo that collapse. There was a proposal by Abdikadir, I wished he had been here, which had made a proposal about how to collapse parastatos in the light of devolution. That did not happen. So I'm saying, if we have a problem of cost of government, that cost is not by the Constitution. That cost is because we have refused to recognize and to respect what the Constitution intended. And in fact, if you are then to actually go number for number and check what is the amount of money that these so-called extensive institutions cost us, it's insignificant in the context of our total budget. We spend 2 trillion shillings. If you check the cost of the administrative structures of devolution, for example, there may be 10, 20 billion shillings. So if there's a problem, let's even accept that there's a problem there. And I agree with Chairman, we would have been more efficient, if the counties were probably less. We could have been, who knows. But if there's a problem, it is not there. The problem is at another level. So I agree that there's a challenge in cost of government, but that cost of government is not because of what was introduced by the Constitution. I think that's a narrative we must reject because it is not true and it is not supported by the numbers.
Thank you very much for debunking this myth that I put forth quite strongly. And as Dr. Njaramba also shares his views on it, a relationship has been said to exist between wealth and democracy, such that countries that are well-to-do are more likely to be democratic, and while those that do not have too much resources, or those that are poor, are always less likely to democratize, the so-called the Lipset hypothesis. Now, as you answer that first question that the distinguished panelists have commented on, do you think that we could have been at any better place now if Kenya was richer?
Thank you. On the cost of the Constitution or implementation of the Constitution, I actually don't use the term expensive. It is not expensive, so I agree that it isn't. So what I look at is the value for money for what Wajiko gets from this Constitution that we have today. Now, and therefore, the issue is how best do we make the Constitution apply efficiently in a manner that is cost effective. And I agree with the other panelists who say that chances are that the problem is elsewhere. And therefore, and this is where we started on saying that we still have a problem with implementing this Constitution because we have certain other things that we do extra or outside the Constitution. There is a chance that that is a problem. But then the end result is that Wajiko is still not getting value for money for the whole structure that we have. Now, to the question as to whether we would have been better if we are richer, or the country is, for me, I would look at it from an individual perspective or point of view. And I'll still go back to the Constitution on the question of socio-economic rights and ask ourselves, how well are we doing by virtue of the Constitution to make the Kenyan better off economically so that he can be able to enjoy the political and civil rights that are given by the Constitution. And that's why I say that whereas perhaps for a very long period of time, when we talk about rights, we look at the civil and political rights. My position has always been that a person who is economically weak can never be in the same position of enjoying rights with a third person who has some economic ability. And that's why I say that or my view has always been that if only we are dealing with economically empowering our people, so that even when the question of political rights, civil rights come in, then they are capable of speaking out. Because one of the challenges that we have today is that when, for example, we get to the point of campaigns, the people who are not politically, economically empowered are easily swayed because of that challenge. And therefore, for us, or for me, I would say that if only we can be able now to put at some faster speed the issue of socio-economic rights of Kenyans. Now, to the issue as to whether we would have been better if the country was better off economically, I don't know how we would have gotten there in the first place with the kind of impunity we have in this country. I don't know how we would have gotten there with the challenges that we have, because if the corruption that we have, for example, cannot allow us to get there. And perhaps in theory, we can say yes, or we can say perhaps. But then the issue is that whether we are ready for that, unless we are, as individuals, we are economically empowered, and as individuals, we are ready to address the challenges at the top to ensure that now everything runs properly, so that we can have finances that can be available to even implement the constitution, and at least to provide for the simple needs that Wajiko needs.
Okay, thank you very much. I'll ask Nedi to ask our second last row of questions.
I like the cost-benefit analysis, because we cannot look at this constitution expenses in isolation. Of course, Wanjiko gets a benefit out of it, as we do have a budget to implement it. And the fact that the implementation and the cost analysis aspect to it has not been brought by the draft itself, but from externalities. Now, when we talk about what Wanjiko really gets from the constitution, I want us to look at the thorny issues. From right away from the onset of the clamor for a new constitution, from the independence constitution, there seemed to have been a widespread cry that there was a lacuna that was presented with the independence constitution, and that is why we were being brought into the Bomas draft, the CKRC, basically what was the harmonized draft that we have today that was done by the COE. Now, when we talk about the thorny issues, I'm looking at the historical land injustice, the question of the land and settlement, yeah? Human rights violations, electoral democracy, and the fact that Kenyans feel they have never gotten the best that they could from the electoral systems, police brutality, which has more and more just taken another tangent in the country. We're talking about nepotism and unequal distribution of resources, or lack thereof. Maybe the distribution has been equal. I will look for your take in it. We have had widespread corruption, much as we have a system and a country that says that we will have zero tolerance towards corruption. We have gender inequalities, that to date, we still ask for affirmative action, and we still ask that the gender balance, the 2/3 majority, our president of the LSK today has spoken to it, and how to constitute elective posts where it comes to the gender question. We are looking at lack of trust in institutions, for example, the judiciary. And why hasn't the president appointed the judges to the seat, even though there are other sitting judges to date? Basically, I've just thrown out a number of the thorny issues that we're dealing with from the Wanjiko, from what they expected of the Constitution, and what we are now telling them you are getting from the text and the implementation of the Constitution. So now, my question to you particularly would be, do you think that the Constitution itself has provided ample provisions for these issues? And if so, where have we dropped the ball in the implementation, and how to address them? Secondly, is Wanjiko, even in the progressive realization of their rights, and in our very beautiful Bill of Rights in the Constitution, do they expect too much of it, or does the state owe it to them to actually bring this out? And as I go there, and seeing as Madam Matsango, biggest champion for rights, gender and otherwise, I'd like to hear you first on these issues.
Oh gosh.
Sorry.
I'm sorry, I didn't think you'd start with me.
I mean, we can start with who is ready.
I don't mind going there. I'll go where you had ended. I think those thorny areas are the areas of contestation, and where the most powerful elements of our society are determined not to let go. And so even as they understood that the Constitution was going to become a reality, they also then began to prepare ways in which they could undermine those provisions. For example, the Constitution provided for us to have a national police service. In the same way as the Independence Constitution had the Office of Commissioner of Police having independence. There were amendments made that have gradually eroded. It happened in the 1960s again. This time now, post the 2010 Constitution, we've had erosions of the role of the National Police Service Commission, the institutions that would have enabled us evolving into a new culture of policing. And so it's unsurprising that we continue to face the problems around police brutality that we are, because there is resistance to the reformation that would result in us having an actual police service. Even if you were to look at something as simple as the leadership structure of the police, which I wouldn't have thought there would be resistance around, that does not satisfy the two-thirds principle. We have, even something as banal as that, let alone the other far more thorough institutions. And so, I'm sorry, the other far more thorough questions. And so I think for me, it keeps coming back to the fact that when you look at these issues, these are the issues that tend to threaten those who, right from independence, we have the interests, the kind of interests that right from independence, and that even led to the independence struggle itself. Land led to the independence struggle itself. It was the appropriation of our land by the British. And so we still have people that own and that have direct interests in not allowing the proper reformation to happen. And I think that we need to understand, which is something that we kept saying during the time that we were working on the Constitution, there are things that are benefits of the Constitution that will not be realized in our generation. And so we shouldn't come to this with the expectation that in our lifetime we will necessarily see these benefits. We should be here looking at these issues as what kind of a country do we want our country to be? And the kind of choices we are making, will they realize those benefits for our descendants, or will they not?
I think that's a very, very weighty question to leave it at. But Dr. Njaramba, maybe just picking up from where she has left it and weighing in on this same question. Kenyans are crying. Kenyans are tired of being taxed. We feel like the tax burden on us is too huge. They work too much to get so little. Weighing still on these same thorny issues and where we are as a country, what's your take?
I think Kenyans have a lot of expectations on the political class. My considered view is that Kenyans should reduce that by half. For the reason that we expect too much from the political class, but perhaps, and this may sound a bit harsh, but they are perhaps not capable of giving the much we expect. And therefore, again, it is us to say that we are not getting it. And of course, I like the way that the courts nowadays are quite able to deal with certain issues that have been taken to court about, of course, human rights violations and the like. And therefore, perhaps it is a step in the right direction. But again, for me, the issue is still, are we able to demand of our leaders that they implement what is there, because we may say in general that the institutions are there. That is, for example, if someone, for example, looks at the question of, let's say, police brutality, we have the National Police Service Commission, and also we have the Independent Police Oversight Authority. And therefore, one can say that the institutions are there. And therefore, the question is, how come, even with these institutions, we still are in the same old problem? And therefore, the problem cannot be with the letter of the law or of the Constitution. It can only be with the implementation. Someone says that perhaps it's an issue of the person sitting in that particular office, but the structure of the office is there. And therefore, the question is, as Kenyans, what do we do to ensure that we get a value for our money from the various institutions that have been established? And therefore, for me, it's all about Kenyans being more vigilant, and of course demanding more from their leaders, and especially when we get to the point of choosing new leaders every other 5 years, then that is where Kenyans, of course, need to work on. But as I said earlier, there is a challenge of Kenyans who do not have economic empowerment, and therefore the challenge is that the problem when they, of course, are improperly influenced, and of course when, of course, we go back to our tribal cocoons for purposes of putting leaders up there. And therefore, the challenge, I think, I'll still push it back to Kenyans so that we lower the expectations on the political class.
Thank you. Mr. Chair, elections remain a big nightmare in our country. We say that we want proper implementation, but then we still sit here and say that the leaders we put in place are not giving us the best of what we should get, yet we are the same ones who put them in those seats. Again, we're still on the thorny issues, and these same issues we have raised. Do you think we can go around how do you think we can best go around our electoral disputes to get the best from the text that we have?
Thank you very much. I think there is a problem of leadership in this country, which is tied to what you are saying. Once you get proper leaders, then you expect proper implementation of the Constitution. And this becomes Wanjiku's responsibility. We cannot babysit this Wanjiku forever, because the leader that you choose is the leader that will represent you. And if you have chosen a bad leader, then don't expect good results. IBC, for example, we created a proper IBC. It conducted elections first time in 2013. They were disputed. There was a proper court procedure which was followed. The Supreme Court declared the election legal. Second time round in 2017, the Supreme Court did its work properly and declared that election illegal. And IBC was commissioned to conduct a further election, but the political class could not agree on that further election, and it degenerated into violence, instability, and so on, culminating finally in the handshake. But the handshake, we have seen that Parliament, the role of minority and majority have been submerged, so that you don't know whether the opposition is now talking for the ruling party or it is vice versa. So it's really a question of leadership and Kenyans assuming responsibility. And that matter that we have alluded to of voter bravery, for example, it is massive. And when you go out there in the rural areas, they just want to elect a person who has given them money, period. Or a person from their tribe, or a person from their clan. That is what we have to do. What can we do to create awareness? This cannot be a matter of the Constitution. It's a matter of taking responsibility for our nation.
Very well, and right from where you have stopped, we are a country that will give to whoever will come and bribe. And in fact, I think that's why we say that we need a secret ballot to vote. But Mr. Waiganjo, at the point where we are, still on the thorny issues, yes? We have seen the same people who will get handouts to vote for one person and still go and complain about the leadership, still look at this same leadership and tell the leadership, we do not have trust in institutions that you have created, or the institutions and the people manning them as has been populated by yourselves. Now, when it comes to something like the appointment of judges, for example, and the faith of Wanjiko in our constitutional system, in our court system, our judicial system, how do you think these thorny issues would have best been handled? Historical land injustices are still something we deal with to date, many years on.
Asante, I think the first thing we need to do on this 10th anniversary is to acquit the Constitution and say the Constitution is not guilty. Because if you look at the letter of the Constitution, it actually has the answers to most of the problems that we are talking about. If you take even the judiciary, the intention of the Constitution in terms of ensuring that you have an independent judiciary that is independent of the executive and independent of parliament is very clear. Now, the fact that we have a judiciary which both parliament in terms of refusing to provide sufficient resources and the executive in terms of refusal to appoint is not a problem of the Constitution. You know, so we need to be very clear where the problems lie. If you take the question of historical injustices, land injustices, the National Land Commission, one of its primary constitutional and statutory mandates is to deal with that issue. In fact, if I'm not wrong, there's actually an act of parliament that even provides for the process of that to be done. If that is not happening, is that a problem of the Constitution? If you look at historical problems on human rights, there's even a report, the TJRC, there's a report in Parliament that has not been implemented. So I think we need to be clear where the Constitution, how far the Constitution can take us, and where the rest of the institutional frameworks that the Constitution has created, and particularly Parliament, because I think we acquit Parliament very easily of a lot of its responsibilities. The transition from the old Constitution to this new Constitution, when it took away the imperial powers of the presidency, it donated those to Parliament. A lot of those Parliament has not utilized, and I think we need to hold Parliament accountable, which is why I agree with the chairman that either because of no sufficient civic awareness or whether it's just because of the character of ourselves as a people, I think we have, again, talking about acquittal. I want to acquit the Constitution and tell you where the guilt lies. Is there sufficient guilt that lies with the people? Because I can almost guarantee that there is not going to be any significant implementation of this Constitution if the people are observers. You know, if they think they are victims and observers, it's not going to happen. But a lot of that has to do with sometimes Kenyans are not aware of the powers that they have and the opportunities they have to push for implementation. If I was to give one very quick example about opportunities that Kenyans don't use, the structures created in the devolved system, which is the one area which was the greatest dividend for Mwananchi in the Constitution, was actually devolution, because you are going to give them an accountable leadership, local priorities, local budgets, local ownership, local accountability. The Mwananchi has not utilized the myriad opportunities that are there for holding counter governments accountable. I always ask, when I do civic education, I ask, your governor leaves or at least visits his office, even if it's once every 2 weeks. If there truly is a problem with the county, even if you just parked and stopped them from going to work, not violently, just for them to address those issues, I guarantee you that there is nobody in that level of leadership who will not take that into account. Your members of the county assembly live in your villages. Why haven't you organized yourselves in such a way that you hold them accountable even physically? Because that is why the structures required them to live there. So I'm just saying that there are certain ways in which we have acquitted the people also from responsibility, even leadership, even elections. There are people we elect who we all know will not deliver, because even the last time they were there, they did not deliver. But we continually like to, and then we do not place that obligation on the people. And so I think in these next 10 years, we must also now require of the citizen a lot more, but that is also going to happen if we are empowering the citizen. Because the truth of the matter is part of the problem is that the citizen is also not aware. They know they passed a constitution, they know it's a good constitution, but in terms of the rights and opportunities that they have, a lot of these they don't know. And for those of us who have the privilege of having that information, either it's professional bodies, the media and other actors, I think in these next 10 years, if we are going to require Wanjiko to hold government accountable, we have a huge responsibility to invest in civic awareness. What will surprise you is that if there's one area where the law even requires civic education and there is no money given to civic education, it is that area. Why? Because anyone in leadership recognizes that a more aware citizen is a problem for you in leadership. So I think we need to own that baton. We need to pick that baton and ensure that we are doing sufficient empowerment for people to take the next 10 years of implementation and not to hold back as victims and hope that government is going to do it. It usually will not happen.
Very well. As we wrap this up, we just want to note that we have not been ignoring Madam Roslyn Odede. She had to leave us because of an emergency she had to attend to, and Mr. Abdi Kadir as well could not join us because he was traveling and could not make it here in time. Now, as we follow through with Mr. Waganjo, what you have just said last about Wanjiko and their guilt in this implementation, there's a question that came from one of the viewers online. It was posed to Mr. Kanjama, but I want to pose it to you in line with what you have said and in the thorny issues that we are dealing with and how we have acquitted the Constitution right now of all this guilt. We have placed the guilt squarely on Wanjiko. The question that, that Mr. Dudley asks is about the fact that the professionals, the KCPF, the Christian professionals said no to this draft at the point of promulgating it. Now, he wants to know, is it true that the fears of this document were valid? Was it valid that the document should not have been brought in? And I'm saying this bearing in mind very well that we have already, through you, acquitted the Constitution of all these evils that are, and blame that is being put on it. Further, is that what role has the religious and professional bodies played in sensitizing and empowering Wanjiko in following up and pushing for proper implementation of this Constitution in the current situation? I ask you this because we know you're a scholar of the good book.
All right, yes, and I'm a card-carrying member of KCPF. I think if you look at the reasons why KCPF raised issue with the Constitution, that is not the problem that the Constitution has. I think there are certain issues that they legitimately raised. You know, they felt that there are certain areas where the Constitution was interfering with you know, embedded moral issues, ethical issues, the questions of abortion, the questions of the right to life and all that. But the problems that the Constitution has produced and the question of citizenship, the problems that we have seen in the Constitution are not those ones. Because don't forget that the Christian community was not rejecting the Constitution in its totality. They were rejecting specific issues. But I don't think those are the ones, the problems that we have. So I doubt that they would say, we told you so, because those are not the problems that have exhibited themselves. What have been the role, the failure, I think, of many institutions, the non-state actor community, is, I think, to fold their hands and assume that either the Constitution would self-execute or that it would be run and implemented by government. And our role is to watch and point and indicate and criticize. And I think in this second phase, this second decade of the implementation process, I think that is an area which the community of non-state actors needs to own as their primary obligation. Don't forget that this Constitution was birthed not by government. You know, it was birthed by that community. And so to then leave it then for government to carry it on was a little naive. And it's like giving birth to a child, and then you give to the person who even opposed the birth of that child to be the one who looked after that child. I think that is unfortunate. And let me just say that I don't think we are saying that it is Wanjiko to blame entirely. I think that would not be right. But it is to say that even as we blame those we have placed in leadership, for example, we have people who are in institutional commissions, independent institutional commissions. You cannot be fired for 6 years. You have a guaranteed salary from the consolidated fund. You know, you have protections, all manner of protections. Why would you not carry out your responsibility? I mean, there's a sense in which we need to hold people accountable to commitments that the Constitution has given them. When they don't, what is the consequence? And I think we let people get away with it very, very easily. But I think what we are saying is that let us also not forget the people. I think we're saying, yes, Parliament is to blame. Parliament has a huge responsibility. We pay them a salary to do certain things. If they don't do it, we must hold them accountable. but surely the person who elects them to parliament, because a lot of these elections are not rigged, by the way, at parliamentary level. They are not. It is people who elect those characters. We need to hold people accountable and to tell them choices have consequences for real, especially when you elect the wrong people in terms of decision making. And maybe because I won't get a chance, what I would have hoped is in a time like this is that the professional organizations actually need to set up a sort of coalition for implementing the Constitution and have very clear time deliverables, very, very clear deliverables, not too many, that are time-bound, that are very clear, that are measurable, which together we can own and say, in the next 1 year, we'll hold the following institutions to account on these very clear issues. If we're talking about amendments of the Constitution, this coalition will then be able to sit together and say, even if we're going to have amendments, these are the minimum things that you must include in that amendment. And I think that is what is lacking, in fact, in terms of a more planned, more structured, more strategic engagement with the process of implementation.
I think that's good. But let us give you a chance to wrap it up, because I think time has gone and we only had 1.5 hours. So maybe we go to our last round of questions and closing remarks.
And of course, if there's something that we must be proud of as the committee of experts or persons interested in the constitutional development process in Kenya, is that there hasn't been a formal constitutional amendment since the Constitution was enacted. If you compare 10 years now and 10 years in respect of the 1963 Constitution, so much had happened within 10 years. The federal arrangements had been brought down. The office of a prime minister had been disestablished. The amendment procedure itself on the Constitution had been changed, and the entire 1963 Constitution had been completely dismembered by 1973. In fact, some people are suggesting that as at 1969, we had a completely new and different constitution. So that now we are celebrating that 10 years down the line, the committee of experts have held the political elites hostage. They just have tried several times to amend the Constitution, but it has not been possible. Every initiative has either landed in Parliament and remained there, or the political elites simply lost interest in whatever they were pushing at that time. Now, with that context, I have 2 questions. Of course, one is that from your comments throughout the session, you have suggested very strongly that there has been an informal process of amending the Constitution, for example, through creation of bodies that were never contemplated. Now, do you think that this informal process of constitutional amendment has been as a result of excessive rigidity on the part of the Constitution, and therefore political elites have to resort to informal mechanisms? That's question number 1. And question number 2 is, the president started by asking, should we change our constitution? And he's recited a number of provisions that he felt he had a problem with. In your own views, do you think that it is time for us to change this constitution through the formal amendment process? And if so, what provisions or what parts of the Constitution do you think we should change? I'll start with the chair.
Thank you very much. You have alluded to rigidity in the present Constitution. There is no such rigidity in the present Constitution. This Constitution is very elaborate and very progressive. It allows Kenyans to enjoy as much as possible the benefits of the Constitution. What has happened is that the political elite, in order to enable their cronies into power, have created structures that were not contemplated in the Constitution. That is, for example, the one we have alluded to, Chief Administrative Secretary. That is an illegal and an unconstitutional office. So that cannot be, because the Constitution is in the harmonized draft. And the purpose of this was to have inclusivity in government. and to have cohesion. So I'm converted myself to the idea that we can have an office of Prime Minister, we can have an office of Deputy Prime Minister, because they are always in the harmonized draft. And we can have cabinet ministers coming from both Parliament and outside Parliament. In fact, the one which I need most is the office of leader of official opposition. We had created a very elaborate office of leader of official opposition, complete with a shadow cabinet, a secretariat, and so on. And you can see that this concept of majority and minority have now been blurred by the handshake. If you had the office of leader of official opposition, he would be able to be in parliament to lead its troops. But you see, the problem has been that once the second most voted person is left out of parliament, the troops have no guidance. The other matter which I think we can address ourselves to as lawyers now is, what do we do with the Judicial Service Commission? The Judicial Service Commission is dominated by judges. And this has led to the problem where, because we had envisaged that judges would be sourced either from the bar, from the academia, or from judiciary. But what has happened in recent appointments is that the judges of appeal who are recommended for nomination are all from the High Court. They left out the bar, they left out the judiciary. So this means that the judiciary has decided to be a judge in its own cause. So we have to think further. What do we do? And my idea has been this. Maybe it was ambitious to give all this power to judges. What we should do probably is to ensure that the chair of the JSC is not the Chief Justice. Maybe he's a retired judge or a senior counsel. We have to have more advocates in the JSC and senior counsels. We have to have public at JSC level and maybe other professionals. Maybe we can retain only one judge. But so speaking of amendments, there are matters that really, even in our own interest, require amendment. And we should not brush them aside. Thank you very much.
Okay, Asango, you think that these parallel institutions are proliferating because we have a rigid amendment procedure that is not easy to overcome, and therefore political elites choose? We will create them, and we take this matter to court. Somebody will challenge it, and if it doesn't succeed, it goes. That's one. And number two, do you think it's ripe now to change the constitution? And if so, what elements do you think need to be changed?
Let me interrupt you a little, Mr. Kubasu. I'm reminded that time is not on our side.
Okay.
So as we continue, let us make answer the questions and give final remarks.
Okay.
And probably look at how to bring back the supremacy of the Constitution, just as we wrap it up.
But I've not given mine.
You've not given yours. We'll give you a chance, I think.
We'll give him, I think, the final chance, yeah.
So wrap it up, give your final remarks, see how we
Yes.
can bring back the supremacy of the Constitution.
What the rigidity means.
Rigidity is that it's not easy to amend the Constitution. Flexibility means that it's easy to change the Constitution. You can, my good colleague, Mr. Waiganjo, knows the Independence Constitution could only be amended within a day, for example, after some changes. Here we have a procedure where once a bill is tabled in Parliament, you people have said it has to take 90 days before a second reading. So the procedure is either you go through a popular initiative, which is quite complex, or you go through a parliamentary initiative, which is also very complex. And that's what I mean by rigidity, so that the question is...
rigidity means you have to consult other people other than yourself when you're the president.
Complexity, basically, that you...
No, it means you have to consult other people other than yourself when you're the president.
Yes.
Yeah. I think, thank you for interpreting it for me. I had no idea what he was talking about. Personally, I was rather baffled, to be honest. And one of my challenges with the political elite is that they speak in very vague terms. And, I've come to the conclusion that they deliberately do so. They've been talking a lot about inclusivity, for example. And yet, when you look at Article 10, it provides, one of the principles is inclusion. And, so we have inclusivity provided for that is not respected. Having a parliament that is predominantly male is not inclusive. And if you have been unwilling to respect that which you already have, are you going to do anything if you get anything new? And so, do I think that there are problems with the Constitution? Yes.
Okay.
Do I think this is the time to change those things? No. I don't trust those that are running this country today to change the Constitution or amend the Constitution in a way that is in the interest of the people. I don't think they care about the interests of the people. That which they are complaining about is not necessarily that which the people of this country are concerned about. I haven't seen evidence of a process that actually sought to find out from the people what their concerns were. Living under a constitution that requires public participation as one of its principles, we have somehow avoided engaging in public participation. So that is my perspective on that. I do think that the challenge today for us as Kenyans is to ensure that we revolutionize. There is no other way to put it. We need to revolutionize our political culture. Kenya is sick. Kenya has people who are unpatriotic as its politicians. The least patriotic people in this country are the political elite, with all due respect to them. I say so because when you look at other countries, when you look at the United States during the time that it was going through that state formation, even if politicians by nature tend to be on the selfish side, there are things that they understood were in the general interests of the United States. When you look at our neighbors like Rwanda, even when the leadership does what it does, I do think that there are things which it understands are in the general interests of the country. So my question to the Kenyan politicians is, in 100 years, where do they want Kenya to be? And when they look at where Kenya should be in 100 years, will Kenya be a leading light in the world? Will it be the place which every single person in the world wants to be with what they're doing? Or will it be some morass that has probably disintegrated if they continue along the path that they are engaged in? So we as the Kenyan people need to understand that we have to demand and create the kind of country that will enable us, because my own personal vision, whether or not, I'm sure I won't be around in 100 years, human nature being what it is, I'll be long gone. But I would like to be, wherever I am Christian, and so I would like to be in heaven looking down and seeing the descendants of Kenya being the people who everybody else around the world goes, wow, I want to be there. Kenya being the one that says, this is how humanity should live. And we can do that. We have every single thing necessary for that. But as long as we are willing to hand over the running of our affairs to people who are mediocre, who are dishonest, as long as we are willing to see people murder, steal, and yet we think that those are the people that we should hand over our country to, well, frankly, if you were hiring somebody to come look after your child, would you pick somebody who had been accused of having killed 3/4 of the kids in the neighborhood? That's the person you're going to have be your nanny. But somehow we hand over our country with a carelessness that to me is fascinating, especially from people who are parents. I'm worried about getting old in a country that looks the way this country looks. And so for me, we need to really take responsibility for who we put in office, who particularly we put in public office. As long as we're not willing to take responsibility for that, as long as we're not willing to hold those people accountable after we are paying them, because we pay them, they're our employees, then, we're going to continue suffering. And now, just my final remark. I am very, very grateful to the LSK and the KCPF for coming together for today. The reason I am grateful to you for doing that is that the middle class and people that are educated have a critical role to play. You have tools available to you that most people don't have. Your lawyers, your engineers, your human resource managers, accountants, you're educated. You can read and write. You have a responsibility, therefore, to work together to ensure that we share with those who don't have those skills, who haven't had the opportunity to go to school, who therefore may not know that they have these rights. We all have a responsibility to make sure that we are educating ourselves and educating and sharing with others. The Freedom Riders during the civil rights movement in the United States were young people who were students that gave up their time, that went out into their communities and were willing to speak with people. This does not require money. It requires a commitment and a love sufficient enough for our country that we say that we want a different and better future for our children. Thank you.
Okay, thank you. Thank you very much for those powerful remarks. Dr. Njaramba, maybe answering the questions that I posed, and then your final remarks and comments.
Thank you. I don't think the Constitution has any problem on the provisions on how it can be amended and so on. So I don't think it has a problem because all it requires is do what is required for you to get your proposed amendments. So to that end, I don't think there is any problem in respect of that. Now, then the other question on is the Constitution ripe for review, for amendments, and so on? I will answer that question in two parts. That number one, I think it is ripe for review, for amendments. And for me, the amendments I see are those ones that remove the institutions that have not added value to AGICO. I'm looking at the various commissions that if we ask ourselves what they have done for 10 years, we can't really see. I'm looking at the question of, for example, do we need 2 houses of parliament? I'm indeed looking at the question of, do we need those numbers that we have in the legislative both at the national level and the county level? So I'm looking at how can we make offices operate together efficiently. So for me, it's more of a reduction. By that just meaning, to be specific, that I'm not looking at an amendment or a revision that is adding any burden to the taxpayer. I'm not looking at an office, for example, of a prime minister, for the simple reason that if indeed we would need additional offices to perform certain duties, then I don't know why we can't still do the same thing at the current dispensation, for the simple reason that the people who will occupy those offices are still with us. So they will not be new. And therefore, if something can be done within this country by creation of a new office, it can still be done under the current dispensation. Now, the second part of that question is this. When? And the question when is, the question may be ripe for amendment, but when is that supposed to happen? I'll go back to where I started. For me, it should be done when Kenyans are sufficiently angry. By that meaning that let us first of all demand and ask ourselves and ask the government, ask the political class, why are we not implementing what we have? Because even if we are made now without having that anger, then whatever comes up, the new one that we may have, it will still be the same thing. So that now it is not about the document, it is not about the institutions. It's about whether the persons we have in office, are they ready to comply with the provisions of the Constitution? And so far, I'm not persuaded that we have capacity today to do better with another document. Now, my final remarks is that, against all odds, I'm still hopeful for a better Kenya, and I still believe that Kenya has a future. And it may be slow in coming what we look at, the constitutionalism we expect in this country. It may be slow in coming, but I still have hope and faith that we will get there. And therefore, baby steps, yes, but then we will still get there. But this, as again I'm saying, is as long as we, the people, make sure that we take the lead and we are not allowing ourselves to be misled by the political class. So only then are we going to see that future that all of us would like to see. Thank you very much.
Welcome. Yes, Advocate Kamodo Waigonjo.
Yeah, maybe 4 quick comments. One is that I probably understand what you mean by rigidity, but that rigidity, if it is rigidity, was deliberate. This was a constitution that was passed by the people. 20 million people, whatever the numbers were, came and voted. I think you must make it difficult to amend. It's only natural. And where there is a legitimate need for amendment, then it shouldn't be difficult to convince the people who voted for it. So I don't think that is the reason why the amendments that have been done informally is actually a support. It affirms the reason why we needed to have a difficult process of amendment. I would challenge someone to go through an analysis of the various proposals for amendments that have been done. I remember the first 2 related to weakening the SRC because it was demanding that the salaries of members of parliament don't be increased. Can you imagine if that was possible to pass? It would have been passed on day 1. Yeah. So there's a reason why those amendments were, the difficult amendment is there. Mm-hmm. Now, in terms of whether it's time for amendment, I think that's an academic discussion. I think if the political establishment wants to make an amendment, I think where the Constitution allows them, I think they will. There is never an ideal time to amend. But I would say this. I think for us as professionals, what we should be saying is what are the principles that should inform any amendments. One is that we need to look out for clawbacks. Some of the proposals being made about amendments are because we have refused to empower institutions. For example, let's take the Senate. There's a huge demand that says, why do we have a Senate? Why do we even need it? It is just costing us more. But that is because we have weakened it, So the solution is not to remove it. It is to strengthen it so that it can't carry out its mandate. The reason for why it was set up still exists. So the solution is not to remove. So we need to be clear that if we're going to amend, we do not have clawbacks. Number 2 is that we need to have the most minimal of amendments. And the reason for that is that we need to ensure that whatever amendments are there are not divisive. The beauty of this constitution is that it is owned by all Kenyans. If we make proposed amendments to it that divide Kenyans in the middle, it means from now on there are people who believe in that constitution and there's another half that believe this is not their document. So we need to be very, very careful that we carry a majority of Kenyans so that the constitution remains our national project and does not become a Kieleweke project or a Tankata, but it becomes a national project which crosses all regions and all areas. Number 3 is that we need to ensure that that constitution has components that are beneficial to the people. What's the need for Ajiko in that constitution? It's all very well to expand the executive, have a leader of the opposition. I think they're beneficial, it's good for the country. But what is the one thing we as professionals can demand that if you're going to have those ones, at least this one which benefits the people must be there? Is it that we need more money for devolution, but ensure you have stronger checks and balances so that the money does not disappear in people's pockets? What is the one thing we need to demand must be there if we're going to have a constitutional amendment? And finally is that we must protect the gains that we have. For all the mistakes and for all the things that have gone wrong, there are very many positive things that have happened. The judiciary is more effective, it's more independent. We must ensure we protect that. So those things, the police, there is police brutality and all, but there's more openness and there's more accountability with IPOA and other institutions. Let us protect those gains however small they are. My final comment is, I think for us I think the differential in the Kenyan elite is not, I don't think there's any elite in any country that does not look out for itself, whether it's a political elite or the financial one. But I think the difference is that we do not recognize there's something called progressive self-interest. Where there are certain things that are good for Kenya, and I also benefit. But this thing that assumes that I only look out for myself, is I think where we are regressive as an elite. If you take something like devolution and more stronger devolved units, those in the national executive see that as a threat. A progressive leadership would know that if you have stronger units, you have less headaches at the top. So you can actually be able to enjoy your leadership without people from all over the country demanding from you. So a progressive leadership looks at what are the things that even as I benefit, the people also benefit. The inability to see that is part of, I think, what sets us apart as sometimes as a political, even a professional elite. What's in it? As lawyers, what's in it that benefits our clients, but it also benefits us as a profession? We need to be able to isolate that, and we don't only look for number one ourselves.
Thank you. And finally, Senior Counsel.
My final remarks.
Yes, your final remarks, kindly.
Are that I've noticed in the last 1 year or so, civil society has gone dead. I do not know why. And that is one forum that can be very important for implementation of the Constitution and even for agitation of constitutional reforms, amendment of the Constitution. So I would urge the leadership of the Law Society to enable or talk to civil society to be more aggressive, to have forums that challenge the problems that Kenyans are undergoing. Finally, I think is to thank you for this forum. I think the message that we have given here is that mwananchi must take responsibility. Lazima achukue jukumu lake. Ikiwa ni kura, lazima apige kura vile anataka. Kusema ati amepewa pesa apige kura, hiyo si shauri yetu. Ni lazima yeye achukue jukumu lake. Thank you very much.
Okay, thank you. Now I'll hand over the program to Herin.
Thank you very much, our distinguished panelists, Senior Counsel Zamba Kitonga, Kamotho Waiganjo, Dr. Jaramba Gishuki, Madam Atango Chesoni. Let us kindly give them another round of applause. To our moderators, Lady Akello, Duncan Okubasu, thank you for a job well done. I will now kindly ask you to take your seat as I invite the next speaker. That is the Vice President of the Law Society of Kenya.
Thank you.
You can. I think. Yes. 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 Just for the session will just take a few minutes. Kindly stay with us. It's our closing session. The Vice President Karibu, she's also the chair of the Lawyer Police Relation Committee. She'll make a few remarks, then invite the Vice President, and finally we'll have a lunch.
Thank you, Herin. Thank you, our powerful panelists. That was a powerful presentation. I think we all live here with something that we've gained from the discourse today. I am standing here not as the Vice President now, but I stand here as the convener of the Lawyer Advocates or Lawyer Police Relations Committee. I would like to make a short speech before I invite the President of the Society to launch some toll-free lines. Ladies and gentlemen, it gives me much pleasure to be here this afternoon to launch the Advocates toll-free hotlines as one of the priority projects of the Law Society of Kenya. These hotlines will be rolled out in all the branches to serve advocates across the country. In the first phase of the project, we launched the national toll-free line 0800-720-434, and the same has been in active use since the 23rd of June 2020. Each branch shall now have a unique toll number through which advocates can reach out to report on incidents of harassment encountered in the course of their professional duties. The National Office, through the Council, graciously supported the branches by procuring the handsets and lines, as well as serving an initial deposit of Kenya shillings 5,000 for the lines activation. On a light note, there goes an old adage joke the famous one by William Shakespeare in King Henry VI, Part 2, who states, "The first thing we do, let's kill all the lawyers." Funny or offensive as it may sound, depending on one's sense of humor, it is a satirical illustration that our noble profession is in its very nature a tad precarious and always under siege. As colleagues, we therefore owe it to ourselves to watch each other's backs, and have measures in place to promote our collective safety and well-being. On a more serious note, advocates are critical players in the administration of justice and the advancement of the rule of law, and play a critical role in the maintenance of a free and just society. Yet, police intimidation, harassment, and extrajudicial killings targeting advocates in the line of duty are commonplace hazards encountered by our members. This year alone, LSK is watching brief in 3 criminal matters in various courts for members assaulted by the authorities while in the course of duty. Ladies and gentlemen, under Section 4E of the Law Society of Kenya Act, number 21 of 2014, the core mandate is to protect and assist the public in Kenya in all matters touching or incidental to the law. The Law Society is a champion of constitutionalism, the rule of law and administration of justice, and upholds the implementation of the Bill of Rights. To achieve its intended objectives, it works with other players to ensure all arms in government are in compliance with the constitutional standards of human rights and fundamental freedoms. In this regard, the Council of the Society continues to seek interventions from the Office of the IG and other duty bearers in the justice sector in synergizing efforts to support administrative and institutional frameworks that will continue to create and consolidate a safe and enabling environment in which both legal practitioners and police are supported and empowered to carry out their professional duties and activities. The Advocate Police Relations Committee has also embarked on formulating guidelines that will further augment its role in seeking to foster relations between the advocates and the law enforcers for the common good of enhancing the administration of justice. I am delighted as the convener of that committee that we are launching this project on this significant day when we are reflecting on 10 years of Katiba, extrapolating on gains made with regards to institutional reforms, including those of the National Police Service, while introspecting on the journey ahead. We would not have done this without the assistance of the Law Society of Kenya President, Mr. Nelson Harvey, and also the council members. So as I conclude, I would like to most sincerely thank the President of the Society and all council members and the Secretariat for supporting this necessary and worthwhile initiative. I also wish to thank the branch chairs who have embraced the initiative and who will be responsible for the day-to-day running of the lines and who will be responsive to members within their respective branches. To the Lawyer Police Committee members for their input and support towards the initiative, and the Secretariat for the technical and administrative support. Without further ado, allow me to invite the President of the Law Society of Kenya before the launch to make his short remarks on this. Thank you, and karibu, President.
the mic on? Iko sauti? Okay, fine. It's on, it's on. Once more, may I thank all of you most sincerely for sparing this day to commemorate Katiba Day. Today, we need to launch 8 toll numbers for the 8 branches of the Law Society. And this exercise is important for various reasons. One, the practice of law is a very perilous practice. Often, our members get into trouble, and they need to be able to access their leaders to enable their leaders attend to their problem. And toward that end, I want to assure the members of the Law Society that the Law Society is part of government. Do you know what the Fourth Estate means? In the recent past, the Fourth Estate has been misconstrued to apply to journalists. The Fourth Estate, as known in the philosophy of law, is lawyers. But it does not mean that we are in bed with the executive, the judiciary, or the legislature. It means we must work together in the manner desired of us under Section 4. And if you remember, on Tuesday this week, we met the Inspector General of Police, who has graciously agreed to work together with the Law Society to ensure that we're able to deliver our mandate effectively. As advocates, it is our responsibility to assist the government of Kenya in combating crime. We will not allow any of our members to be a criminal. In fact, we will deal with you before even the police deal with you. But when you are doing your work, when you're performing your professional duty, we'll be there, and the police will also be there to protect you. Towards that cause, please feel free to use these numbers. They are available for you to reach your branches. We have not given out these numbers merely because we don't want you to call Madam VP or me. Please, my number is still 0722-904-905. Send a lot of M-Pesa to that number. If you have time, call me in the morning, as Kevin Mbogo often does. Call me in the morning, as Ochibaba does, to tell me that I'm doing a good job or that there is some supply of fish that needs to be delivered either to my office or my home. I think we'll proceed there so that we officially launch this noble initiative. Utatoshea Makole? Wapi makasi? Kuja tu pole pole. Yeah, Mike. There is something where I come from, it's called Sigalagala. It's called, there are many lawyers here. Good. Lawyers and lawyers are synonymous, eh? Oh, I'm told also our Shemeji is Luos. And of course, everybody, our Shemejis, Kikuyus and Mukambas also know how to halulilet. Wapi makasi? Ochibaba, your call will come through, so don't worry. I'm told you're anxious whether it will come through. Yeah, we're just trying to activate the line. Don't worry. But don't send that message to this line, eh? You know that message? Tuma fair bus, yeah? George, how are you? You're here. Look around, huh? So by the power bestowed on me as the Commander-in-Chief of all legal forces in Kenya, I hereby officially launch the branches toll line. Thank you, friends. These are 8 mobile phones to enable our members access their leaders. Please make good use of them. We need you protected in the performance of your professional duties. Don't feel alone. You are always under the protective cover of the society. Mungu awabariki.
Thank you, President. Thank you, Vice President. We will ask our distinguished panelists to join the President and Council to take a photo as we celebrate the milestone, the 10-year that we have had the Constitution, and also the launch of the Advocates toll-free lines. Our panelists and our guests representing different professional bodies. Before you leave, finally, I'll ask Mr. Kimosop, if you're here, kindly give a vote of thanks. We request that you give us 5 minutes so that we have a vote of thanks and a word of prayer. And thereafter, you'll all be invited to share with us a meal before you leave.
Okay, yes. Mr. President, the council members, different professionals represented today, members of the Secretariat of the Law Society of Kenya and also the Kenya Christian Professionals Forum, on behalf of the Kenya Christian Professionals Forum, I really want to say a big thank you on behalf of the board, on behalf of its different governance organs, my chair, and also on behalf of the Secretariat to say a big thank you first to the Kenyan people who actually bequeathed us with a constitution in 2010. Because this is the constitution of Kenya. I want to say a big thank you to Kenyans. I want to say a big thank you to the Law Society of Kenya, led by the president, when we had a discussion here to discuss the possibility of having a collaboration, your openness and acceptance to walk the journey together. I want to begin by saying a big thank you to the Holy Family Basilica that actually accepted to do the dedication this morning, because we did not have that session, Mercy, in the absentia, just to thank the leadership of the church, the different churches that were present, thank the Secretariat of KCPF, the Secretariat of Law Society, our technical team that has made this possible, both physical and digital. I want to thank the people who are visible and invisible who've made this a reality, and want to communicate the commitment of the Kenya Christian Professionals Forum to continue partnering with the Law Society of Kenya. Actually, our proposal, if we could be possibly consider adopting this, that we could be doing an annual service and thereafter an engagement of this similar nature as we first begin, as the preamble says, acknowledging the supremacy of the Almighty God, then really taking the personal responsibility by coming and having an interactive session. If I listened to Atsango at some point when she was talking about a multidisciplinary approach, myself, I'm an economist. I could have given even the data about the Constitution so that together we build a country, a community committed to the rule of law, protecting and defending this constitution, so that the Kenya that we've talked about, a Kenya driven by values, by virtues, and a vision for the rule of law is what we will make our contribution towards. And finally, I want to thank my fellow CEO, Mercy, whom we are standing here together for this collaboration. Mercy, I think I like the excellence, I like the organization. May we even raise the standard higher. And to finally say that as people who believe in God, we thank the Almighty God. He's kept us safe and strong, and we are always and will forever be grateful for that opportunity. With that, Mercy, you're welcome.
Thank you, Kimosop. And finally, to our service providers, we appreciate you for the services that you've offered to us. Ford Foundation, thank you very much for your financial support and technical support to ensure that this event has been successful. I will now call upon Beth Michoma, Council Member, to close with a word of prayer.
Let us bow down for a word of prayer. Our Father, we thank you for today. We thank you for the smooth occasion that we have witnessed. We thank you for the wisdom imbued in us, as you have said severally, that if we ask for wisdom, you will give us. We ask you, oh Lord, let us hold our constitution in the importance that it deserves. We ask you, oh Lord, for those who are leaving, give them journey mercies. And for those of us who are staying for a while, oh Lord, thank you for our meal. We pray, trusting and believing in Jesus' name we pray. Amen. You're welcome. There's a meal at the tent. Karibuni.